ಸರಿ
ಮೈಕ್ ಏನಾದ್ರು ಬೇಕಾದ್ರೆ ಕೇಳ್ಕೊಳ್ಳಿ, ಬೇಕು ಅಂದ್ರೆ ಬೇರಲ್ಲಿ ಇಟ್ಬಿಟ್ಟಿಲ್ಲ ಕೆಳಗಡೆ. ಸರ್ ಈ ಮೈಕ್ ವೈರ್ ಕೆಳಗಡೆ ಬಿಡಿದ್ದು ಬೇಕು ಅಂತ ಹಾಕೊಳ್ಳೋದಕ್ಕೆ. ಸಿಕ್ಸಿರ್ತೀವಿ ಬಿಡಪ್ಪ ಕೆಳಗಡೆ.
ಪಿಕ್ಚರ್ ಮೇಲೆ ಓಕೆ.
Any mentioning from video? Any mentionings from video? Yes, memo.
ಫೈನ್ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು ರಿಲೀಸ್ ಆಗ್ತಿದ್ವಿ. ಹೈಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡುವಂತ ಬರ್ದಿಲ್ಲ, ಹಾಗಾಗಿ ನಾನು ಮಾಡೋದಿಲ್ಲ, ರೈಟಿಂಗ್ ಅಲ್ಲೇ ಆಗ್ತೀನಿ.
ಇಮೇಲ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಇಮೇಲ್ ಆರ್ಡರ್ ಬಂದಿದೆ.
What do you want now this court to do? You have got an order.
ಐಎ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ಡೈರೆಕ್ಷನ್ ಟು ರಿಲೀಸ್ ದಿ ಫೈನ್ ಅಮೌಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ. ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಆಗಿರೋದ್ರಿಂದ ಫೈನ್ ಅಮೌಂಟ್ ಬಿಡ್ಬೇಕಂತ ಬರ್ದಿಲ್ಲ. ಅಂಡ್ ಫರ್ದರ್ ಆರ್ಡರ್ ಆಫ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಕೆಪ್ಟ್ ಅಬೈನ್ಸ್ ಅಂತ ಆರ್ಡರ್ ರೈಟಿಂಗ್ ಅಲ್ಲಿ.
What do you want now?
ಐಎ ಫೈಲ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೇಲೆ.
ಹೌದ್ರಿ, ಈಗ ನೀವು ಬರೀ ಆರ್ಡರ್ ಕಾಪಿ ಹಾಕ್ತಿದ್ದೀರಾ, ಏನ್ ಮಾಡ್ತಿದ್ದೀರಿ? ವಾಟ್ ಯು ವಾಂಟ್ ದಿಸ್ ಕೋರ್ಟ್ ಟು ಡೂ ನೌ?
ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಆಗ್ಬೇಕು. ಐಎ ಹಾಕಿದ್ದೀನಿ ಜಡ್ಮೆಂಟ್ ಆಗಿರೋ ಕೇಸಲ್ಲಿ ಐಎ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
ನೀವು ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳಬೇಕು. ನೀವು ಅದು ಹೇಳ್ತಿಲ್ಲ, ನೀವು ಹೇಳಲಿವರೆ ನಾನು ಬಿಡಲ್ಲ. You are eating the time of the other members.
Sorry.
Yes, next matter.
Number 21, my lord.
Yes.
Today for a short explanation, there are total 6 matters, my lord. 2 matters have been posted. Therefore, it is posted. I give the other matter.
At the request of the learned counsel for the petitioner, 10 days time as period is granted as finally. Yes.
Serial number 50.
50. 15. Yes.
Assignment of findings. Given a suggestion to Nagesh. It is called on Monday. The report
Request of the learned counsel for the caveator of the respondent number 2. List this matter in the next week as period. Yes. Hmm. 80. Yes. ಅಲ್ವೇ ಅಷ್ಟನ್ನು ಹೇಳ್ಬೇಡ, ಅದೊಂದು ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲ ಹೇಳಿದ್ವಿ. ಎಸ್ ತಗೊಳ್ಳಿ 17. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಕಾಲ್ ದಿ ಮ್ಯಾಟರ್.
Serial number 1, Sri Sheshadri NS for the petitioner, Rajesh Gowda for R1 to 3.
I am appear for the respondent, Your Honor.
Where all the respondents are dead.
ಹೌದು ಸ್ವಾಮಿ.
There are counsel for the petitioner neither present physically nor through video conference. There are counsel for the respondent who is appearing through video conference submits that in spite of granting sufficient opportunities, the petitioner has not taken steps to ensure bringing of the legal representatives of all the respondents who are all deceased, who are all dead. On 2/3/2022, this court had made the following observation. In view of the above, when the learned counsel for the petitioner himself has stated that all the respondents are dead and the petitioner is not giving him any instruction to proceed further in this matter by furnishing the necessary details of legal representatives, if any, of the deceased respondent. From it has to be inferred that the petitioner is not evincing interest in prosecuting the matter. Accordingly, the petition stands dismissed for non-prosecution.
Serial number 2, Sri Ningegowda for the petitioner.
As mutual sentence says, the petition is also a old petition of the year 2016.
Serial number 2, Sri Ningegowda for the petitioner. Sri M. Venkatappa for auto. R3 is served.
Only trying to step.
ಇದನ್ನೆಲ್ಲ ಕೂಗಿಸ್ತಾ ಹೋಗ್ಬೇಡಿ. ಕೂಗಿಸೋದ್ರೊಳಗೆ ಒಂದು ಸಬ್ಮಿಷನ್ ಶುರು ಮಾಡಿರ್ತಾರೆ. Learned counsel for the petitioner physically present and prays for a week's accommodation to take fresh steps to ensure the notice upon answered respondent number 2. The petition is of the year 2017. As such, passing a peremptory order holding that in case the petitioner fails to furnish the correct, complete, and present address of answered respondent number 1, and take appropriate steps in the registry within a week from today, the petition would stand dismissed on its own without any further hearing by this court with effect from 18/3/2022 as a final opportunity. A week's time as paid is granted. Yes.
Serial number 3, Sri Varun for the petitioner. Sri V. Anand for R2 and 3.
None appear. Petition is of the year 2017. In spite of granting several and sufficient opportunities, the petitioner has not ensured the service of notice upon respondent number 1. Hence, the petition as against respondent number 1 stands dismissed for not taking steps. In the above circumstance, the maintainability of the petition as against the remaining respondents also is required to be done.
Serial number 4. Chidanand Kumar for the Chidanand Kumar M for the petitioner, YK Narayan Sharma for R1.
My lord, I am for respondent number 1. The taking of steps regarding the R6 may not arise because of the simple reason, my lord, that I am plaintiff and others are all defendants. And in defendants jointly filed 1 to 5 written statement containing accepting that the property is joint family property, etc. Though relationship was disputed. Then after the evidence is over, now second defendant files an application for amendment of the written statement, joint written statement, contending that the property belonged to grandmother and there was a will. And as per the will, it has come and it is a separate property, not joint family property. Totally a new case. That is rejected. And now that it is a common defense they have. Now defense number 6 is not served. Respondent number 6 is not served. Steps are not taken. Stay is granted and the suit is pending. And it's a common defendant or a defendant who is not interested in the amendment nor contested the amendment. So for this list regarding the amendment is concerned, R6 may not be a necessary thing. That is why I would request your lordship to direct the petitioner to either to give up 6 or make a statement. R6.
What is your submission? Yes, let's say no relief is sought for assignation R6 and he is only a formal party. The only contesting respondent is the plaintiff who has been served and being represented. Therefore, you can seek the dispensation of notice to R6. That's what the other side submits. What do you say?
Kindly keep this matter next week, my lord. I will verify and do it, my lord, because he is arrayed as a defendant number 6. Yes, my lord, he is necessary party.
No, I am not saying that he cannot contest. What I am saying is for the purpose of this amendment, he is not necessary to be heard. The amendment is sought by R2, defendant number 2,
Amendment
and I am the
is sought
plaintiff
by
R1.
2. The present respondent number 6 need not be heard in that matter.
It's not present respondent is also one of the defendant in this suit. Hence, my lord, I made it. I made arranged
No, he is one of the defendants, but so far as amendment is concerned, he has no say either in the trial court or in this court.
Please, my lord,
In this matter, as such, according to him, says unnecessarily say the matter is dragging on because of non-service of notice to him.
No, my lord.
Even if he comes, he cannot say anything. It is only you and the respondent number 1 who have to make their submission on the impugned order.
ಇದರಲ್ಲಿ ನಾವು ಏನು ಡಿಲೇ ಮಾಡ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಅವರು ಸರ್ವಾಗಿದೆಯೋ ಏನೋ ನಮಗೂ ಗೊತ್ತಿಲ್ಲ. ಅದು ಈಸ್ ಒನ್ ಆಫ್ ದಿ ಡಿಫೆಂಡೆಂಟ್ ಅಂಡ್ ಈ arrayed as one of the respondent in this matter, my lord. Hence notice is ordered by the honorable court. ಬಟ್ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಡಿಲೇ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ. ನೋ ವೇ
ಡಿಲೇ ಬಿಡಿ. ಈಗ ಅವರು ನೆಸೆಸರಿ ಇಲ್ಲ ಅಂತ ಆದ್ರೆ ಯು ಕ್ಯಾನ್ ಸೀಕ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅನ್ನೋದು ಅವರ ಸಬ್ಮಿಷನ್.
ಆಯ್ತು, ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ನಾನು ಅದನ್ನ ಮಾಡ್ತೀನಿ. ನಾನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. I will do it.
Counsel for the petitioner is physically present. Counsel for respondent number 1 is appearing through video conference. Counsel for respondent number 1 submits that respondent number 6 is not a necessary party in this petition, since the alleged amendment was sought for by the defendant number 2, which was opposed by the present respondent number 1 as a plaintiff in the trial court. As such, the respondent number 6 would have nothing to say in this writ petition. With this, he prays that petitioner may be persuaded to seek dispensation of notice to respondent number 6. Next, learned counsel for petitioner prays for a week's accommodation to make a submission in that regard. List the matter in the next week.
5. Sri Nayak NR for the petitioner.
None appear for petition. None appear in this matter either physically or through video conference. The perusal of the order sheet would go to show that in this petition of the year 2017, till date, the petitioner has not ensured the service of notice of respondent number 1. Sufficient opportunities has already
time, my lord. The respondent number 1, my lord. Respondent number 2, my lord, the already. And the
petitioner 2 weeks time was granted. In spite of the same, the petitioner has not taken steps. As such, it has to be inferred that the petitioner is not interested in prosecuting the matter as against respondent number 1. Accordingly, the petition as against respondent number 1 stands dismissed. Next one. Since the petition as against respondent number 1 has to dismiss, the maintainability of the petition as against the remaining respondent is also required to be heard in the petition. Yes.
Seal number 6, Sri Prasad B.S. for the petitioner, Sri S.K. Acharya for R1, 2, 4, 7 to 9.
Yes.
Prosecution will not on the piece of memo filed with the respondent number 8. Respondent number 10 died. There is a reason, my lord, I filed application that application. Application is not made. I have to file a fresh application for implement the loss of the respondent number 10. And the respondent has to clarify either that the respondent number 1 or the respondent number 10 died. That's the reason, my lord, this is supported.
Respondent number 1 is alive. Respondent number 1 is alive. I have filed the power for respondent number 1. And respondent number 10 is died, he died prior to the.
There are counsel for petitioner and respondent number 1 are physically present. The counsel for the petitioner reiterates his submission made on 28/2/2022 that respondent number 1 is alive. As on date and is being represented by his counsel. The counsel for respondent number 1, who is respondent number 1, submits that respondent number 1 is still alive and he continues to appear for him. In that way of the matter, it is taken that respondent number 1 is alive. As such, the observation made on 11/11/2021 to the effect that respondent number 1 is reportedly dead stands recalled.
Died on 4/10/2012. Number 10 died on 4/10/2012.
No, that is over already. It's only with respect to respondent number 1. Yeah, he's taken as alive.
I filed an application before the trial court that they are not the legal heirs of the original decree holder.
Because of the microphone, please.
I filed an application in the FDP proceedings, my lord, saying that, my lord, I filed an application in FTP proceedings, my lord, saying that, my lord, the original degree holder died. After that, my lord, they filed these respondents are filed the application saying that they are the degree holder, the legal heirs of the degree, original degree holder. I filed an application. They are not suspected that, my lord, they are not the legal heirs of the original degree holder. Without holding any inquiry, trial court, my lord, allowed the application filed by the respondents.
Sir, the matter is not as simple as you put it. Here you might have repaired what a damage that was caused, probably at your instance. So in the impugned order to set it right, it requires a detailed hearing. You will have it in the next week. I agree. Yes. Yes.
Seal number 7, Sri Jagdish DC for the petitioner, Sri S.R. Muralidhar for R1A and B.
I am for the respondent, my lord. Respondent number 1, my lord. I am for the respondent number 1, my lord.
Yes.
My lord, the stay is going on since past 4 years, my lord. This is the 2018 matter, red petition. The respondent number 5 to 7, 2 to 7, whatsoever the PF is to be taken, they are uncontesting defendants, my lord. They are uncontesting defendants, and the contest is being going on only between me and the petitioner. Petitioner is the defendant number 3 before the trial court and the plaintiff, my lord. And therefore, the notice may kindly be dispensed with, my lord. And the stay is going on from past 4 years, and the trial court proceedings are stayed because of this.
What is the impugned order?
Amendment. Amendment of prayer and application came to be allowed. That is challenged by the petitioner before this court.
The amendment application was filed by the plaintiff.
Yes, my
Yes,
lord.
that was rejected.
No, that is allowed, my lord. That is allowed.
That was allowed. So, which defendant you are?
Third defendant.
You are defendant number 3. Yes, the contesting party is only the respondent number 1. He has been served already. Why don't you seek dispensation of notice with respect to the remaining respondents?
All the respondents as parties in the suit.
Yes, sir. Definitely. That is true. That is true. For adjudication of the alleged amendment sought for by the plaintiff and which amendment is said to have been allowed by the trial court. Other defendants have not opposed that allowing of the application. It is only you who have opposed that. You are before us. You can address your argument if you are really aggrieved, and we will hear you completely. The person who would be aggrieved by the order of this court passed, if any, would be the respondent number 1. He is being represented by the council now. Then where is the necessity of the remaining respondents? They can be dispensed. Say the notice can be dispensed to them.
They are placed ex parte and they have not come before the
No,
court.
notice can be dispensed to them.
I will make a necessary application.
I will pass over the matter. File a memo.
Yes, please, ma'am.
Monday or Tuesday, madam. By the time I will make it.
And the stay may kindly be vacated, my lord.
So
2012.
court officer will provide you a white sheet of paper.
Monday, madam. By the time I get it.
His sole ground is that the prayer is
Counsel
barred by
for the
limitation.
petitioner is appearing physically. Counsel for respondent number 1, A and B, is appearing through video conference. Counsel for respondent number 1A and B submits that he is the only affected party. He would be only the affected party on any order that may be passed in this direct petition. The remaining all respondents who were the defendants number 2 to 7 in the trial court are all formal parties in this petition. The present petitioner, who was the defendant number 3 in the trial court, agreed by the order passed by allowing the amendment application filed by the plaintiff has preferred this petition. Thus, the notice as against respondent number 3 to 7 be dispensed with. Okay. However, learned counsel for the petitioner prays for 2 days accommodation to make his submission, including filing of a memo seeking dispensation of notice to unserved respondent.
The stay may kindly be vacated, my lord.
List the matter on 14. List the report. 14.3. Yes,
Please.
the interim order granted earlier is extended till 14.3 or 2 to 7.
Serial number 8, Sri Pramod R.
At the request of the learned counsel for the petitioner, has finally a week's time is credit granted. In case the appropriate steps are not taken, registry to list this matter on 18.3.
Serial number 9, Sri Sirajuddin Ahmad for the petitioner, government is served.
Counsel for the petitioner not present, neither present physically nor through video conference, learned SCGP upon whom the advance copy was served alone is physically present. The perusal of the order sheet would go to show that in this petition of the year 2021, in spite of granting sufficient time, the petitioner has not complied the office objection. Even in the absence of the learned counsel for the petitioner also, this court earlier has granted adjournment to enable the petitioner to comply the office objection. Since the petitioner has neither complied office objection nor shown any reason for his non-appearance today, the petition stands dismissed for non-compliance of office objection as well for non-prosecution.
Number 10, Sri Mallikarjun BC for the petitioner, SCGP for one.
I have heard copies, response 3 and 4 on 21/1/2022 and I got the acknowledgement. On the work copy, response 3 and 4.
Lord, I appear for respondent number 4, my lord.
Nothing to this one, any copy of the response. Anything that the subsequent copy of Annex K.
No, 1 minute, 1 minute, 1 minute, please. Whether 1 minute, please. Whether notice to respondent number 3 has been served?
Yes, 3 and 4.
One second. ಒಂದು ನಿಮಿಷ ವಕೀಲ್ರೆ.
My lord, I'll secure. I am for respondent number 4, my lord. I'll
One
secure-
moment,
Please.
one moment. You appear for even respondent number 3 also.
My lord, I undertake to appear. I'll secure the wakalat, my lord. I'll file wakalat, my lord. R3 is the chairman. Now there is no members, so it is by administrator. I will secure the wakalat for R3. I filed already filed wakalat for
Counsel for
R4.
the petitioner is physically present in the court. Learned counsel for respondent number 4 appearing through video conference undertakes to file wakalat for respondent number 3 also. He is permitted to file wakalat. He is permitted to take notice even for respondent number 3 and to file wakalat for respondent number 3 in the registry within 10 days from today. Is this matter? ಅಲ್ರಿ ವಕಾಲತ್ ಹಾಕೋರು ಅವರು ವಕಾಲತ್ ಅವ್ರು ಹಾಕ್ತಾರೆ. ನಾನು ಅವ್ರಿಗೆ ಅವ್ರು ಕೇಳಿದ್ರು 10 ದಿವಸ ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ ಟೈಮ್. ಯಾಕೆಂದ್ರೆ ನಿಮ್ಗೆ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇದೆ, ನಿಮ್ಗೆ ಲಾಂಗರ್ ದಿ ಬೆಟರ್ ಅಂತ ಇಸ್ಕೊಳ್ಳಿ ಅದೇನು. Pursuant to the memo filed by the learned counsel for the petition, interim order granted earlier stands extended by 2 weeks from today. Yes.
Much obliged, my lord.
Number 11, the Lokesh Shah for the petitioner, Sri M. Nageshwar, came for respondent number 2.
You have been served with the copy.
Yes,
Served with the
sir, on 3/21 itself, but in respect of.
You are yet to comply the another office objection.
Please, my lord.
Yes, comply the office objection.
My lord, R1, R3 and R4 notice are ready.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ನೋಟಿಸ್ ಮೆಚೂರ್ ಆಗಲ್ಲ. ಅವ್ರಾದ್ರೆ ಕೇವೇಟ್ ಅವರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಮಾಡಿರಲಿಲ್ಲ, ಅದಕ್ಕೆ ಬಂದಿದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡುವ. Learned counsel for the petitioner and learned counsel for K-Waiter are physically present. Learned counsel for the K-Waiter acknowledges the service of copy of the memorandum of this petition to him. In view of the same, the office objection at serial number 1 stands complied with. A week's time is granted to the petitioner to comply the remaining office objections.
Number 12, Sri Muhammad Sabanullah for the petitioner, Lokesh for came for respondent number 2.
Represent alternate. Authority copy.
Received the copy.
Received.
Same order ಮಾಡಿ ಅದರಲ್ಲಿ K-Waiter or petitioner K-Waiter or present ಅದೆಲ್ಲರೂ ಇರಲಿ. Accordingly, office objection serial number 2 stands complied for remaining. For compliance of remaining office objection 1 week.
13, hearing on IA.
I
Sri
pay for
Eastern Work with the petitioner, Rajshekar K for the respondent.
I pay for the petition. The last hearing date, there was a direction to file a fresh application for the bringing the LRs of the deceased respondent. I'll file the application today itself. Kindly grant a week's time. I'll file the application today because application was filed for the bringing in the LRs, but it's not in the proper lane because all the three prayers were not mentioned in the application. That is the reason there was a direction. I've prepared it and I'll file it today itself.
But there is a conditional order passed by this honorable court, my lord, to deposit 50% of the decretal amount, my lord.
Lord, as far as that is concerned, we have deposited the amount.
And if there is, my lord, 5/7/2017 is the date on which conditional order was passed to deposit.
That conditional order is complied with. And
Today,
moreover,
they will not deposit.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೇವೆ ಅಂತಿದ್ದಾರಲ್ರಿ. That condition of deposit has been complied with ಅಂತಿದ್ದಾರಲ್ಲ petitioner counsel.
My London plan doesn't have any wakalat as of respondents.
ಅವ್ರು ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರಿ ಏನು ಅಂತ ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ಬೇಕಂತ್ರಿ.
I'll furnish it, my lord. Within a week, I'll furnish all that things. Kindly grant a week's time.
But 19/2/2018.
My London plan doesn't have any wakalat for the respondent as already deceased. LRs are not brought. I don't think he could make any submission.
I may be directed to take him. LRs, the deceased respondent.
ಅವ್ರು ಇನ್ನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿಲ್ಲ, ನೀವು ಕೂಸುಟ್ಲಿಕ್ಕೆ ಮುಂಚೆ ಕೊಲಾಯಿ ಹೊಲಿತಿದ್ದೀರಲ್ರಿ.
I may be directed to take notice for LRs of the deceased respondent.
If he is my London friend taking a notice.
To take notice upon whom? On what?
For the LRs of the deceased.
On what you take notice? On what you take notice?
There is a direction from. Sorry, there is an instructions from.
ನನಗೆ ILR ರಿಪೋರ್ಟಿಂಗ್ ನಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಯಾಕೆ ಆಗ್ತಾ ಇದೆ ಅಂತ ಈಗ ಗೊತ್ತಾಯ್ತು ಅಲ್ವೇ. ಅವ್ರು ಇನ್ನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಲಿಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ಮೇಲೆ ತಾನೇ ಯಾರೆಲ್ಲಾರು ಏನು ಅಂತ ಬರೋದು, ಅವಾಗ ತಾನೇ ನೋಟಿಸ್ ಬರೋದು. ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರು ಲಾಂಗ್ ಬ್ಯಾಕು. ನೀವು ಅಬ್ಸೆಂಟ್ ಇದ್ರಿ, ಅದು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ಸ್ ಇತ್ತು, ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇವತ್ತು ಇನ್ನೊಂದು ಹಾಕ್ತಾರೆ ಅವರು. ನೋಡಿ ಇಲ್ಲಿ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ಅದು ವಕೀಲರುಗಳಿಗೂ ಕೇಳ್ಬೇಕು, ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಕೇಳ್ಬೇಕು, ಇವ್ರಿಗೆ ಅವ್ರಿಗೆ ಕೇಳ್ಬೇಕು. ಕ್ಲಿಯರ್ ಆಗಿ ಕೇಳಿದವ್ರೆ ಬಹಳ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗ್ತದೆ ಐದರ್ ಸೈಡ್. ಅದನ್ನ ಹೇಳಿ ಸಂಬಂಧಪಟ್ಟವ್ರಿಗೆ ಮಾಡಿ. I will pass over the matter, Mr. Counsel, for petitioner. You ascertain the details as to when the
Lord, as far as that is concerned, my lord, kindly grant.
When the order of when the court is talking, if you interfere, I will stop hearing.
I'm sorry, my lord. Sorry.
Ascertain from your client as to when the interim direction of depositing a portion of the amount has been completed by him. You ascertain those details and make submission.
Kindly grant a day's time or two. For that, I will make the submission.
Learned counsel for the petitioner is appearing through video conference. Learned counsel for the respondent is physically present. Counsel for the petitioner submits that during the course of the day he would be filing application in the registry seeking to bring the legal representatives of deceased respondent on record. However, duly serving the copy thereof to the other side. At a submission made by the learned counsel for the respondent that the petitioner has not yet complied the direction given on 5/7/2017 and which was further modified on 19/2/2018, till date, the learned counsel for the petitioner prays for a day's accommodation to ascertain from his client and make submission in that regard. This is the matter on 11/3/2022.
Please.
Yes.
Seal number 14. Sri B.K. Manjunath for the petitioner. Yes, sir. Regular hood limit for R1 8 to F. Number 14.
Here for the question of release. 2012-2019, this honorable court was pleased to grant time to take steps to second responding. Respondents CLRs have already been served, my lord. Condition that if our steps are not taken.
Two options, Mr. Counsel. Either you should keep present the learned counsel for R1A to F, Mr. SR Hegde Hoodle money, or you are required to take notice. Option is yours. If you request him to be present, and if he present, then we can proceed further in the matter without ordering notice.
I understand, ma'am. I will take steps to the respondent.
No, I'm talking about R1A to F. R2 invariably you have to take steps.
That's right. Ma'am.
So far as R1A to F.
R1A to F, Mr. Hegde.
That is what I am telling you, sir.
Right.
This matter was dismissed earlier.
Yes, please,
You
ma'am.
are now seeking to recall this as order of dismissal.
That's right, ma'am.
Other side should know.
Yes.
You should not be satisfied that okay, the matter is dismissed, therefore bundle ಕಟ್ಟಿ ಮೇಲೆ ಇಡಪ್ಪ ಅಂತ ಹೇಳೋರು ಮಾಡಿರ್ತಾರೆ. ಅವರಿಗೆ ಈಗ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅನ್ನೋದವ್ರ ತಿಳುವಳಿಕೆಗೆ ಬಂದು ಅವರು ಇಲ್ಲಿ ಹಾಜರಿರಬೇಕು. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡದೆ ನಾವು ಮುಂದುವರಿಬಹುದು.
Please, ma'am. Take notice.
ನೀವು ಹೆಗ್ಡೆ ಅವರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಅವರನ್ನೇನಾದ್ರು ಬರ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರೆ ನಿಮಗೆ ಆ 7 ಮಂದಿಗಳಿಗೆ ನೋಟಿಸ್ ತಗೊಳ್ತಕ್ಕಂತಹ ವೆಚ್ಚ ಸಮಯ ಎಲ್ಲದೂ ಉಳಿತದೆ. ಆಯ್ತು, ಯಾವುದಕ್ಕೆ?
1 week.
Counsel for the petitioner alone is physically present. Prays for a week's accommodation. A week's time has played his friend.
Number 15 is adjourned. Fresh matter, cell number 16, CH Devaraja.
Not the short point, not the configuration. Avoiding the compensation, not and removing the fruit bearing trees. Cultivation cost has not been deducted, that portion will have to
Is it necessary for calculate or deduct the alleged cultivation cost for these kind of the trees?
Trees which regard the fruit bearing trees. The trees not, I am not sure for that question. Only fruit bearing trees, coconut trees. 49 coconut trees. The court notes that relying on the Dodaka judgment, that it is Sarah's law that their observations made, but while calculating law, that it has not been.
Probably the cost of cultivation for coconut tree was also not intended by the court below. It is after considering all, for each coconut, a particular price has been assessed.
Yes, sir.
What error can be found in that?
That's my kindly blast that Dodaka judgment in para 26, my kindly blast. In the coconut trees, 30% is 50. Will be cost will be 30%. I'll pay it. $26, man.
It is after giving margin to the cost of cultivation only the trial court has taken the.
It has not been taken that.
Yes, please.
The cultivation cost has not been deducted here.
Cultivation cost, it has not expressly calculated, but it's considered after considering the cost of cultivation, the coconut value per piece. was taken at a particular amount. In Dodaka's case also, that was not calculated expressly. Even in Dodaka's case also, though it mentioned that 30% is the cost of cultivation for fruit-bearing tree. With respect to the coconut, it said after considering the cost incurred for cultivation per coconut, this amount can be taken. That is what. See, reading the paragraph 27 of Dodaka's case. 27. Read 4 lines, please.
Keeping in mind the ratio laid down by the above judgment, the multiplier of 10 is required to be taken, and if the cost of the cultivation is taken at 30%, it can be safely said that the income has to be calculated on the basis of the 5 rupees per coconut, giving a margin.
Giving margin to the cost incurred for cultivation and other expenses.
Yes.
It has not arithmetically calculated there also. It said, okay, we will take 30% as the cost of cultivation. After considering all those aspects, say per piece, as on that day, 5 rupees should be okay.
That year must be taken is 10 rupees.
That is true, sir. Which year?
That year, that I am not disputing that the taking 10 rupees per yield is concerned and the price is concerned. But that only that the grievance is that it is a cost of the cultivation which is 30%, which has not been deducted.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ನೀವು ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಬರ್ತೀರಿ. ಕಾಸ್ಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಅನ್ನ ಅವರು ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಮಾರ್ಜಿನ್ ಅಮೌಂಟ್, ಆಫ್ಟರ್ ಸೇ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಕಾಸ್ಟ್ ಇನ್ಕರ್ಡ್ ಫಾರ್ ಕಲ್ಟಿವೇಶನ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಇಂಟೂಂಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ. ದೊಡ್ಡ ಕಾಸ್ ಕೇಸಲ್ಲೂ ಅವರು ತೆಂಗಿನಕಾಯಿಗೆ 15 ರೂಪಾಯಿ ಅಥವಾ ತೆಂಗಿನಕಾಯಿಗೆ 7.5 ರೂಪಾಯಿ, ಅದರಲ್ಲಿ 30% ಕಾಸ್ಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಡಿಡಕ್ಟ್ ಆದ್ರ ಮೇಲೆ 5 ರೂಪಾಯಿ ನಾವು ತಗೊಳ್ತಿದ್ದೇವೆ, ಹಾಗೆ ಹೇಳಲಿಲ್ಲ. ಅವರು ಕೂಡ ಕಾಸ್ಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಫ್ರೂಟ್ ಬೇರಿಂಗ್ ಟ್ರೀಗೆ ಇಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಅಂತಿದೆ, ಅವೆಲ್ಲವನ್ನೂ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆಫ್ಟರ್ ಗಿವಿಂಗ್ ಮಾರ್ಜಿನ್ ಟು ದಿ ಕಾಸ್ಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಪರ್ ಪೀಸ್ ಕೋಕೋನಟ್ ಪ್ರೈಸ್ ವಿ ಫಿಕ್ಸ್ ಅಟ್, ವಿ ಟೇಕ್ ಇಟ್ ಅಟ್ rupees so and so ಅಂತ ಹೇಳಿದ್ದಾರೆ.
18 man, improved judgment I mean, permit me to ignore that. Page 7, internal page 20 in the bottom.
Internal page?
Internal page plus 20. The bottom left.
Yes.
Admittedly, in the year 2010 and 11, the rate of value per coconut was at 6 rupees. The petitioner has filed this petition in the year 2013. Therefore, considering the evidence of PW3, Senior Assistant Director of Horticulture, Tumkur, who got issued a Exhibit P7 yield certificate, and also evidence of Exhibit P4, that Secretary APMC, who had issued a Exhibit P6 rate bill, the rate for coconut can be taken at 10. But the assessment year 2010 and 11, by taking yield 125 coconuts and the price for coconut is ₹10 and issuing the multiplier of 10 for 18 coconut trees, if the net value is worked out, it comes so far as that is.
So your only grievance is towards the cost of cultivation.
That's only that coconut.
Take up. The present respondent as a claimant in criminal miscellaneous petition, civil miscellaneous number 158/2013 on the file of the Fifth Additional District and Session Judge Tipturu, Brevity Trial Court. Section 16(3) of the Indian Telegraphic Act, Brevity Act, had claimed compensation with interest thereupon on the ground that the present petitioners had drawn 100 kV electricity transmission lines in her agricultural land bearing survey number 196, measuring 4 acres, and survey number 207, measuring 1 acre 22 guntas, situated at Sulekere village, Kasba Hobli, Turvekere Taluk, Tumkur district. She also contended that the petitioner herein had used the land of 22 meters width and have cut and removed 49 coconut trees aged about 13 years, 3 tamarind trees aged about 20 years, 19 neem trees aged about 25 years, 1 early tree aged about 25 years, 1 hippet tree aged about 20 years, 39 bamboo aged about 20 years, and 2 kagli trees aged about 20 years. Despite the same, she was awarded with a compensation of a sum of 2,29,691 by the present petitioner. Agreed by, she had sought for enhancement of the said compensation. The trial court, after hearing both sides and recording the evidence laid before it, awarded the compensation in the following manner. 1. For 49 coconut trees, rupees 6,12,500. For 9 neem trees of 18 years old, 40,500. For 10 neem trees, of 8 years old, 20,000 rupees. For 3 honge trees, 7,500. For 39 bamboo cele, rupees 19,500. Total sum of rupees 7 lakh. Added to this, added to this 7 lakh. After deducting the amount of rupees 2,12,388, which was said to have already been granted, the trial court held that the petitioner before it was entitled for an enhanced compensation of a sum of rupees 4,87,612 with interest thereupon, with interest at the rate of 8% per annum from the date of filing of the petition till the date of recovery. Challenging the same, the respondent in the trial court have filed the present petition. The only contention of the learned counsel for the petitioner here is that while granting the compensation, while calculating the compensation towards fruit-bearing tree, which is the coconut tree in the instant case, the trial court also have deducted 30% towards the cost of cultivation. The learned counsel for the petitioner submitted by virtue of judgment reported in the executive engineer KPT CH-10 and another versus Dodaka reported it so and so. 30% was to be deducted towards cost of cultivation while calculating compensation towards coconut tree. Since the trial court has not deducted this at cost of cultivation, he is before this, the petitioners are before this court. The counsel for the petitioner considers that with respect to the quantum of compensation awarded for the other trees, he has no grievance. Next line. Though this matter come up before this court as a fresh matter to consider interim prayer, however, the court thought that the petition itself can be disposed of. Accordingly, the submission of the learned counsel for the petitioner was heard in extensively, where he reiterated the above point. Next line. In Dodaka case, bracket Supra, at paragraph number 26, the Honorable Apex Court though has observed that the cost of cultivation in respect of fruit-bearing trees will be 30%. However, in the very same judgment at paragraph number 27, the Honorable Apex Court has taken a total value of ₹5 per coconut bracket for the relevant year in the said case, after giving margin to the cost incurred for cultivation and other expenses without actually making an arithmetical calculation regarding the yield, the price of each coconut, and the 30% cost of cultivation. Even in the case on hand also, the trial court, while calculating the compensation towards coconut tree, though it has taken the price of each of the coconut at ₹10, by giving reasons as to why it is taking such a price, has also shown that the said arrival of the price is after giving margin to the cost incurred for cultivation. Thus, it is not that the trial court has not considered the cost of cultivation. Even in the said case, The trial court also, though has not automatically calculated the cost of the price of the coconut prior to the deduction of 30% towards cost of cultivation. However, before arriving at price, before arriving to the price at rupees 10 per coconut, it has considered the it has given margin to the cost incurred for cultivation. Therefore, the only contention of the learned counsel for the petitioner that the trial court has erred in. The trial court has not considered the cost of cultivation in calculating the price of the coconut and arriving at compensation is not acceptable. Except this, since the petitioner has got no other grievance, I am of the view that even without ordering any notice to the respondent, the present petition, things can be disposed of as it is devoid of merits. As it is devoid of merits, the petition stands dismissed. ಸಣ್ಣ ಕಾಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಇದೆ ಕೊಡಿ. ಅಲ್ಲ, ಸ್ಮಾಲ್ ಅಮೌಂಟ್ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಕಾಸ್ಟ್ ಆಫ್ ಕಲ್ಟಿವೇಶನ್ ಅಂತ ನೀವು ಕೊಡೋದು 2 ಲಕ್ಷ ರೂಪಾಯಿ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಅವ್ರೇನು ವಕೀಲ್ ರೇಟ್ ಇಲ್ಲೆಲ್ಲ ಬಂದು ಗುದ್ದಾಡೋದ್ರೊಳಗೆ ಅವ್ರಿಗೆ ಅದ್ರಲ್ಲಿ 20,000 ರೂಪಾಯಿನೂ ಕೈಗೆ ಸಿಗಲ್ಲ ಅವ್ರಿಗೆ.
Admission, Seal number 17, Sri H.N. Basuraju for the petitioner, Sunil K.N. for the respondent.
Respondent, madam. Sorry, madam. Previous date I have undertaken. I have informed the party, madam. They have not sent the wakalat. Wait weeks time, madam. I will pay the wakalat.
My lord, I am appearing for the petitioner in this matter, my lord. May kindly short accommodation may kindly give my lord some inconvenience also.
Counsel for the petitioner appearing through video conference prays for a short accommodation. Simultaneously, Learned Counsel Shri Sunil K.N., who is physically present, also pays for a week's accommodation to file wakalat for respondent. A week time as spread is granted.
In the hearing, Seal number 18, Sri Jagdish H.T. for the petitioner, government for respondent.
1 to 6, your lordship.
None appear for petitioner. Learned HCGP for R1 to R6 alone present, hence the matter could not be proceeded.
Seal number 19, Sri Srinivas K. for the petitioner, government is served.
You take notice for all the three.
Yes, Your Worship.
The counsel for the petition physically present heard his submission. You noticed the respondents learned. SCGP takes notice for respondent number 1, 2, and 3. Pray for time to file her objection, if any, to the petition. Why didn't you produce the originals of these documents? What you have produced? All the originals must be with you only.
Yes, my lord.
Your correspondence with you.
Correspondence.
Yes, produce the originals.
Put it, by next year.
Yes.
Place the entire.
The have furnished with a copy of IA 1/22.
Yes, my lord.
I1 has been produced.
I filed the,
And
wrote the
this-
copy and filed it in the.
File objection to the writ petition as well to IA 1/22. In the meantime, the learned counsel for the petitioner is in the meantime, the petitioner to file the originals of the documents which are sought to be produced by him under IA 1/22. Yes.
Zero. Bill number 20. Sri Naveen GS for the petitioners, Sri VR Sarthi for R1, Sri Mahesh for R3 and R4.
It's a petition filed against the order of trial court under order 6, rule 16, my lord.
One moment.
Yes, my lord.
Yes, please.
Lordship, filed before the trial court for a partition matter.
Yes.
Wherein after filing of the claim, the defense number one has filed the registration.
Order 1660. Yes.
That's in written statement para 18, 17, 18, 19, and 24, my lords. There are certain averments made by the defendant number one, which are not necessary for deciding or adjudicating the present suit, my lords, since it's a partition suit. On the same ground, in the trial court, an application under Order 6, Rule 16, along with 151 has been filed, my lords, to expend certain arguments made in the written statement. The trial court was pleased to dismiss the application, my lords, stating the ground that page 51, typed copy of annexure E, my lords.
1 minute.
Page 51, typed copy of annexure email.
1 minute.
Yes, sir. Thank you.
Yes, please.
Lordship may kindly take page 51 of typed copy of the annexure, my lords.
Yes.
The application under order 6 rule 16 read with 151 dismissed on 2 grounds, my lords.
Yes.
One ground that the statement made in the written statement is not defamatory, and the provision
Made in the written statement
is not defamatory. And the second ground on which the application was dismissed was that order 6 rule 16 application is a suo motu proceeding and it cannot be filed by the plaintiff, my lords. Now, your lordship may kindly take page number 28, my lords. Para 17, my lords. They have stated that after getting the house set out the
which
demand
page,
number,
which para?
page 28, my lords, para
Yes.
17 of the written statement.
Yes.
Last but sixth line, my lords.
Yes.
The defendant number 2, the plaintiff and his mother have started to ill-treat the daughter of first defendant and they have harassed her. They have treated cruelty both mentally and physically, and one day because of their harassment, the daughter of first defendant Hemalata was committed suicide, my lords. And in next paragraph, my lords, para 18, they have stated that as such, thereafter the first defendant came to know that they have murdered his daughter for the purpose of said house, which is having heavy worthy. As such, the defendant number 2, plaintiff and his mother have neglected the first defendant and harassed him, and they were only for the money. The said aspect of cause of death of Hemalata was known to the plaintiff after some time. In para 19, my lords, they have stated that as such, the defendant number 2, plaintiff and his mother have colluded themselves and they have tried beaten the first defendant. The mother of the plaintiff, by name Sarojama, has collided with her son and she has showed hostile interest towards the first defendant, and she is not treating the first defendant as her husband. As such, Sarojama was neglecting and deserting the first defendant without any valid reason. The said Sarojama has also dedicated her life to God and she was very much interested in spiritual matter, and every day she was busy with puja and other spiritual aspects. She has shown attitude towards the first defendant. She herself has forced the first defendant to get second marriage since she is dedicated her life to God. Then, my lords, page number 31, para 24, my lords. Wherein they have stated the plaintiff, second defendant, and his mother are in a habit of beating the first defendant, and finally on 21/11/2011, they have beaten the first defendant through slippers, and he has given complaint against the plaintiff to the Essekote police station, and they have registered a case against them in CR number 414 of 2011 for offence punishable under section 340 and pending, my lords. I would like to draw this honorable court attention to our judgment of this.
What it says? First, tell me the summary.
It very clearly says that if the material facts are not related to decide or adjudicate the matter, same should not be pleaded or averred in the pleadings, my lords. That is what Supreme Court says.
Then why did you call your father irresponsible?
My lords?
Why did you call your father irresponsible? You are an advocate.
Yes, my lords.
You should know.
Yes, ma'am.
You have filed a suit for partition.
Yes, ma'am.
You want property.
Yes, ma'am.
But you have called your father irresponsible.
In my plain, my lords.
In your claim. So ನೀವು ಮಾಡಬಹುದು, ನೀವು ನಿಮ್ಮ ಹುಚ್ಚ ತಂದೆನ irresponsible ಅಂತ ಕರಿಬಹುದು, ಬೇಕಾದ ಕರಿಬಹುದು. ನಿಮ್ಮ ತಂದೆ ನನ್ನ ಮಕ್ಕಳು ಊಟಕ್ಕೆ ಹಾಕದಿದ್ದಂಗೆ ಮನೆಯಿಂದ ಹೊರಗಡೆ ಹಾಕಿದ, ನಾನು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಹೋದೆ ಅಂತ ಹೇಳೋದು ನಿಮಗೆ ಅದು ಸ್ಕ್ಯಾಂಡಲಸ್.
No, my lords. My father has deserted me, my lords.
ಅದು ಬಿಡಿ, ಈಗ ನೀವು ಬೇರೆದಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನೀವು ಅನ್ವಾರಂಟೆಡ್ ಥಿಂಗ್ ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಈ ನಿಮ್ ಪ್ರಕಾರ ಮಕ್ಕಳು ನಾನು ಹೊರಗಡೆ ಹಾಕಿದ್ರು, ನಾನು ಪೊಲೀಸ್ ಹತ್ರ ಹೋಗ್ಬೇಕಾಯ್ತು, ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಬೇಕಾಯ್ತು ಅಂತ ಹೇಳೋದು ನಿಮಗೆ ಸ್ಕ್ಯಾಂಡಲಸ್. ನೀವು ತಂದೆನ ಇರ್ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಂತ ಕರೆಯೋದು ಅದು ಡಿಫಮೇಟರಿ ಅಲ್ಲ. ಈಗ ಓಪನ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನೀವು ಇಲ್ಲ ಇವಾಸ್ ಥ್ರೋನ್ ಇನ್ನೊಂದು ಅಂತ ನೀವು ವಾಟ್ ಯು ಆರ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಸೇ. ನಿಮ್ ಫಾದರ್ ಹೇಳಿರೋದು ತಪ್ಪು, ಈಗ ನೀವು ಕೋರ್ಟ್ ನಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ನಿಮ್ಮದೇನು? ವಾಟ್ ಇಸ್ ದಿಸ್ ಡ್ಯುಯಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್? ನೀವು ನಿಮ್ಮ ಪ್ಲೀಡಿಂಗ್ ನ ಎಷ್ಟು ಬೇಕು ಅಷ್ಟಕ್ಕೆ ಕನ್ಫೈನ್ ಮಾಡಬಹುದಿತ್ತಲ್ವೇ?
Yes, my lords.
You have provoked your father to tell many more things. After provoking, you say that your father ought not to have stated.
But since my father has deserted me and
Exactly, sir. Your
Yes,
father
madam.
deserted you according to you.
yes, my lord.
Even without mentioning that your father deserted you, or without calling your father irresponsible, you should have drafted the plaint,
Yes,
continued the suit.
Indeed, indeed.
Therefore, say what was not required, you have mentioned in your plaint, calling your father as irresponsible.
My lord, sir, my intention
And you said that your father had never taken care of you, it was Kamalamma who had taken care of you. Whether those pleadings, the averments in the plaint were required, not required.
Yes, my
So
lord.
that provoked your father to give his version of the family background. How he was treated by you, your mother, and how his daughter died in a suspicious circumstance, and only to avoid giving share to her in the property, what plan you did.
No, my lord.
ತಂದೆ ಹೃದಯ ಹೇಳಿತು, ಯಾಕೆ ನೀವು ಅವರನ್ನ ಉದ್ರೇಕಿಸಿದಿರಿ ಹಾಗೆ ಹೇಳಲಿಕ್ಕೆ. ನೀವು ನಿಮ್ಮ ಪ್ಲೇಂಟ್ ನ ಕನ್ಫೈನ್ ಮಾಡಿದ್ರೆ ಬಹುಶಃ ನಿಮ್ಮ ತಂದೆ ಹೇಳ್ತಿರ್ಲಿ.
Kindly, my lord, my intention was not that, my lord.
ನಿಮ್ಮ ಫಾದರ್ ಇಂಟೆನ್ಷನ್ ಈಗ ನಿಮ್ಮ ಜೈಲಿಗೆ ಹಾಕೋದಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟಿನಲ್ಲಿ ನೀವು ಹೇಗೆ ಮಾಡಿದ್ದೀರಿ, ನಿಮ್ಮ ಕಂಡಕ್ಟ್ ಏನಿದೆ, ವಾಟ್ ಮೇಡ್ ಹಿಮ್ ಟು, ವಾಟ್ ಕಂಪೆಲ್ಡ್ ಹಿಮ್ ಟು ಸೆಲ್ ಸಮ್ ಪೋರ್ಷನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ವೆನ್ ಹಿ ವಾಸ್ ಡೆಸರ್ಟೆಡ್, ಅಂಡ್ ಅಟ್ ಯುವರ್ ಹೆರಾಸ್ಮೆಂಟ್ ಅಂಡ್ ಪ್ರೆಸರ್ he had to sell some of the property. ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಯಾಕೆಂದ್ರೆ ನಾಳೆ ದಿವಸ ಬಂದಾಗ ಅದನ್ನ ಶೇರ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದನ್ನ ಅವ್ರು ಮಾರಾಟ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅವ್ರು ನುಂಗಿ ನೀರು ಕುಡಿದಿದ್ದಾರೆ, ಹಂಗಾಗಿ ಅದ್ರಲ್ಲಿ ಅವರಿಗೆ ಶೇರ್ ಇಲ್ಲ. ಅದ್ರಲ್ಲಿ ನನಗೆ ಬರ್ಬೇಕಾಗಿರೋ ಶೇರನ್ನು ಈಗ ಉಳಿದಿರೋ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಏನು ಅವ್ರಿಗೆ ಶೇರ್ ಹೋಗುತ್ತೆ ಅದು ನನಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಕೊಡಿ ಅಂತೀರಿ. ನಿಮ್ಮದು ಬಹಳ ಯೋಜನೆ ಅಪ್ ಟು ಜುಪಿಟರ್ ಇದೆ, ಅವ್ರದ್ದು ಇನ್ನು ಮೂನೇ ರೀಚ್ ಆಗಿಲ್ಲ ರಾಕೆಟ್.
No, my lord.
ನೀವು ತಂದೆ ಅನ್ನೋದಕ್ಕೆ ಬೆಲೆ ಕೊಟ್ಕೊಂಡು ಸ್ವಲ್ಪ ಪ್ಲೀಡಿಂಗ್ ಅನ್ನ ಗೌರವಯುತವಾಗಿ ನೀವು ಪ್ಲೀಡ್ ಮಾಡಿದ್ರೆ ಈ ಪರಿಸ್ಥಿತಿ ಬರ್ತಿರ್ಲಿ.
My lord, sir, they have clearly stated that she has, in page 29, my lord, last two lines. She herself has forced the first defendant to get second marriage since she's dedicated her life to God, my lord. The first wife has dedicated her life to God. That's why he got married for the second time.
ನೀವು ವಿಷಯಾಂತರ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ನಿಮ್ಮ ತಂದೆ ಎರಡನೇ ಮದುವೆ ಯಾಕೆ ಆದ್ರೂ ಈಗ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಹೌದು ಸರ್.
ಪ್ರಶ್ನೆ ಇರೋದು ನೀವು ಚಪ್ಪಲಿಯಿಂದ ಹೊಡೆದು ಅಪ್ಪನ ಹೊರಗಡೆ ಹಾಕಿದ್ರಿ
ಇಲ್ಲ
ಅಂತ ನಿಮ್ಮ ಮೇಲೊಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು SD ಕೋಟೆ police station.
ನಿಮ್ಮದಂತ ನಿಮ್ಮ ಅಣ್ಣನ ಮೇಲೂ ಹೇಳಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್. ಅದೇ ಪ್ಲಾಂಟ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಅಣ್ಣ ಸುಮ್ಮನೆ ಇದ್ದಾರೆ. ನಮ್ಮಪ್ಪ ನನ್ನ ಮರ್ಯಾದೆ ತೆಗೆದ ಅಂತ ನಿಮ್ಮ ಅಣ್ಣ ಹೇಳಲಿಲ್ಲ.
He has been arraigned as
ಅವ್ರು ಸುಮ್ಮನೆ ಇದ್ದಾರೆ. ನೀವು ನಿಮ್ಮ ತಂದೆನ ಇರ್ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಇತ್ಯಾದಿ ಇತ್ಯಾದಿ ಕರೆದು ನಮ್ಮ ಅಪ್ಪನ ನೋಡ್ಕೊಂಡಿದ್ದಲ್ಲ ಕಮಲಮ್ಮ ಅಂತೆಲ್ಲ ಹೇಳಿದಾಗ ನಿಮ್ಮ ಅಪ್ಪನಿಗೆ ಕೆಲವೊಂದು ವಿಷಯಗಳನ್ನು ಹೇಳುವ ಅನಿವಾರ್ಯತೆ ಉಂಟಾಗಿದೆ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮುಂದೆ ನೀವು ಈ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಶೇರಿಂಗ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಬಂದಾಗ ನಿಮ್ಮ ಯೋಜನೆ ಪ್ರಾಜೆಕ್ಟ್ ನಂಬರ್ 2 ಅವಾಗ ಬರುತ್ತೆ ಕೋರ್ಟಿನಲ್ಲಿ. ಅವಾಗ ಬಂದಾಗ ನೀವು ಮುಂಚೆ ಹೇಳಲಿಲ್ಲ ಅಂತ ಬರುತ್ತೆ. ಓಕೆ ಹೇಳ್ರಿ.
My lord, sir.
No, yes, no.
My lord, sir, I would like to make a few submissions. Para number 17 ಅಲ್ಲಿ ಅವರು suicide commit ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಈ ಕೋರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದು ಸೂಯಿಸೈಡ್ ಮರ್ಡರ್ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ ಫಾದರ್ ನೀವು ಮರ್ಡರ್ ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಆಕೆ ಸೂಯಿಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ಳು, ಮಗಳು ಸೂಯಿಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ಳು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Pertaining to which a complaint has been filed.
ಅದು ಬೇರೆದಾಗ್ತದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವೆದರ್ ಇಟ್ ವಾಸ್ ಸೂಯಿಸೈಡ್ ಆರ್ ನಾಟ್ ಅಂತ ಹೇಳಲ್ಲ. ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಲ್ಲ. ಆಫ್ ಕೋರ್ಸ್ ಆ ಕೆಲವೊಂದು ಪೋರ್ಷನ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ, ತೀರಾ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಕ್ಕಿಲ್ಲ. ನೀನು ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 9 ಆಫ್ ದ ಕ್ಲೈಂಟ್ ಓದಿ ಒಮ್ಮೆ. ಓದಿ ಗಟ್ಟಿಯಾಗಿ.
In fact, the plaintiff's well-being and education were taken care of by the maternal grandmother Srimati Kamalamma, as the plaintiff was good at studies. The plaintiff is a practicing advocate in Bangalore, though the plaintiff thought of not to litigate, but the irresponsible and
ಓದಿ ಗಟ್ಟಿಯಾಗಿ ಸ್ಪಷ್ಟವಾಗಿ ಓದಿ.
But the irresponsible and wayward conduct of the first and the second defendant compelled the plaintiff to approach this honorable court for the relief of partition and other incidental relief.
ಅಂತೆಲ್ಲದೂ ಹೇಳಿದ್ದೀರಿ. ಆಗ ಖರೀದಿಯಾಗಿ ಹಾಗೂ ನೀವು ಪ್ಲೇಂಟಿನ ಹಾಕ್ಬೋದಿತ್ತಲ್ವೇ?
Indeed.
ಹಾಕ್ಬೋದಿತ್ತಲ್ವೇ? ಮತ್ತೆ ನೀವು ಕಮಲಮ್ಮನ ತಂದು ಕಮಲಮ್ಮನನ್ನು ನೋಡ್ಕೊಂಡಿದ್ದು ನಮ್ಮಪ್ಪ ಇರ್ರೆಸ್ಪಾನ್ಸಿಬಲ್, ವೇವರ್ಡು ಇತ್ಯಾದಿ ಇತ್ಯಾದಿ ಎಲ್ಲ ಹೇಳಿದ್ರಿಂದ ಆ ತಂದೆ ಅನ್ನತಕ್ಕಂತಹ ವ್ಯಕ್ತಿಗೆ ತನಗೆ ಮನೆಯಲ್ಲಿ ಏನು ಟ್ರೀಟ್ಮೆಂಟ್ ಇತ್ತು ಮಗನಿಂದ ಅಂತ 2 ಪ್ಯಾರ ಹೇಳುವ ಅವಶ್ಯಕತೆ ಬಂತು. ನೀವು ಏನು ಮಾಡಿದ್ರಿ, ಕೆಲವೊಂದು ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಬೇಕು, ಲೋನ್ ರೈಸ್ ಮಾಡಲೇಬೇಕು ಅಂತಕ್ಕಂಥ ಅನಿವಾರ್ಯತೆ ನೀವು ಯಾಕೆ ತಂದ್ರಿ ಆ ಪ್ರಾಪರ್ಟಿಗಳ ಮೇಲೆ ಅನ್ನೋದನ್ನು ಹೇಳ್ಬೇಕಾದ್ ಬಂತು. ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ದಿವಸ ಅನ್ನೆಸೆಸರಿಲಿ ಫಾರ್ ಇಸ್ ಪರ್ಸನಲ್ ಬೆನಿಫಿಟ್ ರೈಸ್ ದಿ ಲೋನ್ ಎಲ್ಲವನ್ನೂ ತರ್ತೀರಿ. ಯಾಕೆಂದ್ರೆ ನೀವು ತಂದೆನ ಇರ್ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅಂಡ್ ವೇವರ್ಡ್ ಅಂತ ಕರೆದಿದ್ದೀರಿ.
ನಾವು ಆರ್ಡರ್ 6 ರೂಲ್ 16 ಅಲ್ಲಿ ಅವರು ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿದ್ದು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಕೇಳಲಿಲ್ಲ. ನಾವು ಕೇಳಿದ್ದು ಅವರು ಒಂದು ಸೂಸೈಡ್ ಕಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದ ಬಗ್ಗೆ ಹೇಳಿದ್ದು. ಮತ್ತೆ ಎರಡನೇದು
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 17 to 19 and 24 ಡಿಲೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೇಳಿದ್ದೀರಿ
ಅಷ್ಟೇ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 17, 18, 19 ನಲ್ಲಿ ಬೇರೆ ಬಹಳಷ್ಟು ವಿಷಯಗಳು ಹೇಳಿದ್ದಾರೆ. ವಾಟ್ ಕಂಪೆಲ್ಡ್ ಹಿಮ್ ಟು ಸೆಲ್ ದಿ ಪ್ರಾಪರ್ಟಿ, ವಾಟ್ ಮೇಡ್ ಹಿಮ್ ಟು ರೈಸ್ ದಿ ಬ್ಯಾಂಕ್ ಲೋನ್, ಅದನ್ನು ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
ಅದು ಪ್ಯಾರಾ 17 ಮತ್ತೆ 19 ಅಲ್ಲಿ ಎಲ್ಲೂ ಲೋನ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ.
Why her daughter committed suicide? That means say you wanted the property not to be shared with the daughter. ಹೇಳಿದ್ದಾರೆ ಅದನ್ನು.
That is not my lord.
ಹಾಗಾಗಿ ಇಶ್ಯೂಸ್ ಬೇಕು, ನೀವು ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದಾಗ ಬೇಕಾದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿ, ವಾಟ್ ಆರ್ ದೇ ಆರ್ ರೆಲೆವೆಂಟ್ ಆರ್ ನಾಟ್ ಅಂತ ಫಸ್ಟ್ ತಂದೆಗೆ ಗೌರವ ಕೊಡೋದನ್ನ ಕಲಿ.
Yes, my lord.
Just take down. The present petition was a plaint. The present petitioner is a plaintiff in OS number 211/2012.
We are ready to amend the plaint with respect.
Absolutely not.
Irresponsible and
Absolutely not.
Great.
211/2012 against the present respondents number, against the present respondents for the relief of partition of his alleged 1/3 share in the plaint schedule properties and for possession. The defendant number 1, who admittedly is the father of the plaintiff bracket present petitioner, and shown to have and has been shown of age at 68 years as on the date of institution of the suit in the year 2012, comma, has filed his written statement. In the said written statement, he has, in the said written statement, particularly in paragraph number 17, 18, 19, and 24, he has spoken about the conduct of his other family members, including the plaintiff, and the unnatural death of his daughter, and how he was being ill-treated by his family members, including the plaintiff, and the second defendant. Being honored by the said portion of the written statement, particularly in paragraph number 17 to 19 and 24, the plaintiff filed an interlocutory application the order 6 rule 16 read with section 151 CPC in the trial court, seeking the striking out of averments of pleadings made by defendant number 1 in his written statement at paragraph number 17, 18, 19, and 24. The trial court, after hearing both sides by its impugned order, stated 19/6/2015, rejected the said IA, the IA number 9 ಅಂತ ಮಾಡಿದ್ವಿ, rejected the said IA number 9. Agreed by the same, the petitioner, agreed by the same, the plaintiff in the trial court is before this court as a petitioner. From both sides. The counsel for the petitioner submitted that the statement made in the written statement, paragraph number 17, 18, 19, and 24, which also since made certain allegations against the plaintiff, the same are not necessary for the suit, as such they are required to be expunged or directly to be deleted. Who appears for respondent number 1?
I appearing for the respondent number 1.
Yes. What is your submission?
I have replied in pursuance to the allegation made by me, and moreover, they have deserted me. And what circumstances I have compelled to sold the property.
One submits that those paragraphs which the plaintiff want to strike out now are in response to the plaintiff averment made at paragraph number 9, and that as a father of the plaintiff, the defendant number 1 has depicted the true picture. As such, they cannot be called either defamatory or unnecessary, and cannot be ordered to be strikeable. Next line. In paragraph, in the alleged paragraphs 17, 18, 19, and 24, the summary of paragraph number 17, 18, 19, and 24 is that the contention of the plaintiff that he was brought up by one Srimati Kamalamma is not correct, and that the plaintiff, joined by his elder brother, who is defendant number 2, and his mother, Srimati Sarojamma, started ill-treating the sister of the plaintiff, who is none else than the daughter of defendant number 1, only for the purpose that the house property should not go to her. As such, he said the daughter Hemalata committed suicide. It is further stated by the plaintiff that it is further stated by defendant number 1 in his written statement that the plaintiff, second defendant, and his mother are in a habit of beating him, bracket the first defendant, and finally beating him, which made him to approach a jurisdictional police and to lodge a complaint against them. Sapyara, it is the above contentions of the defendant number 1 taken up in his written statement. The plaintiff want to strike it out under Order 6, Rule 16 CPC. The very same plaintiff, the plaintiff himself in paragraph number 9 of his plaint has stated as below, copy mode. In fact, the plaintiff's well-being fall in the dental relief, incidental relief. Okay. A reading of para 9 in the plaint above shows it clearly that the plaintiff, admittedly being the son of the defendant number 1, who is his aged father, has called his father as irresponsible and having wayward conduct. When a father is being called by his son in a suit for partition as irresponsible, having with wayward conduct, and that the father has not taken care of him, but it was Srimati Kamalamma has taken care of him. Naturally, the said father, in his written statement, has attempted to give some details about his family and how he was being treated by the family members. In the said process, the said father, defendant number 1, has not just confined of accusing his one son, that is plaintiff, but also has made the common remark even as against his another son, that is defendant number 2. The said son has not raised any objection for such a remark made by his father in his written statement. In those paragraphs of the written statement, the defendant number 1 has also attempted to show as to, apart from the plaintiff, who were other alleged sharers were there with respect to the property, including a house property, and how the life of that alleged sharer, who was her daughter, came to be terminated in an unnatural manner. He has also shown in his written statement as to what compelled him to raise some bank loan and to manage himself when he was alleged to have been deserted by the other members, not only by the plaintiff, even by defendant number 2 also. That being the case, though those portions of the written statements were not very much necessary for adjudication of the real dispute between the parties, but the plaint averment at para 9, which is extracted above, has compelled the father to mention his version of the case in paragraph number 17, 18, 19, and 24. Further, deletion of those paragraphs in the written statement, but retaining para 9 of the plaint may in due course enable the plaintiff to come up with his additional or improved version, if any, of his father selling some portions of this, his father selling some of the items of some of the alleged joint family property to the subsequent to the purchasers, who are the other defendants in the suit and are not family members of the plaintiff and the defendant number 1 and 2. It is in this such circumstance and also considering the fact that the plaintiff has called his father irresponsible and of wayward conduct person, since the pleading in the written statement at paragraph number 17, 18, 19, and 24 have come out, I do not find that there are any reasons either the court on its own to strike off those portions of the pleading or directing the defendant to delete them. As such, I do not find any irregularity or illegality in the impugned order warranting an interference at the hands of this court. As such, the writ petition stands dismissed as devoid of merit.
Submission, Lordship. Shall I make one submission, Lordship? Shall I make one submission, Lordship?
No. Yes.
21 is adjusted. 22 Sri Deepak J for the petitioner, Sri K. Shivshankar for 1 to 5.
My love, in this matter, my petition, my love, may kindly take this matter on Monday. My love, there is inconvenience to them.
Regularly, you have been taking time.
My love,
Regularly.
Please, my love, my inconvenience, my love, the document had been produced in Kannada. Unfortunately, I don't know how to read and write, so I'll just get the translation done, my love.
You should have done that, say, by this time. It's a 5 years old matter, right?
Yes, my love, Monday I'll do it, my love, without pay.
ನೋಡಿ ಆ ಪರಿಸ್ಥಿತಿಗೆ ಬಂದಿದ್ದೇವೆ. ಕರ್ನಾಟಕದಲ್ಲೇ ಹುಟ್ಟಿ ಬೆಳೆದು ಕರ್ನಾಟಕದಲ್ಲೇ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋ ವಕೀಲರುಗಳಿಗೂ ಕೂಡ ನನಗೆ ಕನ್ನಡ ಬರಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಕನ್ನಡದ ಡಾಕ್ಯುಮೆಂಟ್ ತರ್ಜುಮೆ ಮಾಡ್ತಕ್ಕಂತಹ ಆ ತರ್ಜುಮೆನ ಪದದ ಅರ್ಥ ಹುಡುಕೊಳ್ಳಿ ನೀವು ಮಾಡೋದ್ರಲ್ಲಿ. ಪ್ರಯತ್ನ ನಾನು 5 ವರ್ಷಗಳ ಕಾಲ ಮಾಡ್ಲಿಲ್ಲ. ನನ್ನ ಭಾಷಾ ಜ್ಞಾನದ ಕೊರತೆಯಿಂದಾಗಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ 5 ವರ್ಷಗಳ ದೀರ್ಘಕಾಲ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ದು ಕಕ್ಷಿದಾರರಿಗೆ ಅನಾನುಕೂಲ ಆದ್ರೂ ಅದಕ್ಕೆ ನಾನೇನು ವ್ಯಥೆ ಪಡುವುದಿಲ್ಲ ಅಲ್ವೇ? Counsel for R1 to R5 physically present. At the request of the learned counsel for the petitioner, who is appearing through video conference as a final opportunity, a week's time as spread is granted.
Serial number 23, Sri A.J. Nagaraj for the petitioner, Sri Rajkumar for R6, Shankar Reddy for R8.
Next year, A is the improved order.
One moment, please. Respondent number 7 was a contesting defendant, right?
5 to 8 are the contesting defendants, my lord. And
They are not being represented here.
please, only for the respondent number 8 is represented, please, my lord.
So we'll appoint an amicus curiae for the other 2 respondents.
Please. One is represented.
There are counsel for the petitioner. Alone is physically present. After seeing the impugned order, it appears that apart from respondent number 6, who is being represented by the learned counsel, the respondent number 5 and 7 are also contesting defendants in the trial court who had opposed the joint memo filed in the trial court, which has invited the impugned order. As such, before proceeding further, an amicus curiae be appointed for respondent number. Be appointed for respondent number 5 and 7. There are counsel. Srimati Archana came, who is present in the court, is appointed as amicus curiae for respondent number 5 and 7. The petitioner to furnish memorandum of petition, memorandum of petition along with its annexures to the learned amicus curiae within 3 days from today. Since the writ petition has arisen out of an order passed in a proceeding in a original suit, and since the learned amicus curiae may be required to go through the pleadings and other necessary papers of the original suit, the learned counsel for the petitioner, which petitioners were the plaintiff number 1 and 2 in the trial court, are also directed to furnish the copies of those documents available with them to the learned amicus curiae at her request. List the matter after 2 weeks. You first furnish her the writ petition copy and annexure. Let the amicus curiae go through that. If amicus curiae wants any further thing like the client written statement, etc., a photocopy of the same you can furnish.
And only question is that this writ petition arising out of only the modification of the simple order, the trial court has committed error.
Exactly. That simple modification would affect the interest of defendant number 5 there. That is it. It is very simple for you. Very sensitive for the court. That is why an amicus curiae is appointed. And your joint memo was opposed by those 2 defendants for whom the amicus curiae is now appointed.
Number 24.
Appear for the
Nomination for the petitioner, Sri K. Anand for R8.
appear for the R8 and R9, my lord. Behalf of Anand K, my lord.
The petitioner before your lordship and the respondents 1 to 6, they are members of the land family. The petitioner as a plaintiff filed for partition, your lordship, and that was almost considered by the others defendants in the suit. At that stage, respondents 8 to 13, who have nothing to do, they make an application to implicate themselves as a party in my partition. And if your lordship kind enough to see the application,
It is as broad as it can be. And we filed a detailed statement of objection stating that earlier in 1997 itself, there was a partition between my father and their father and their brothers. And in that partition, properties have been partitioned everything. And therefore, they have nothing to do with our properties of families are totally different from their family. But very strangely, the point which is not pleaded, case not pleaded by them, the learned judge makes out, it appears some properties have not partitioned into the earlier partition. Therefore, they are necessary. And in fact, all these details is nothing to be shown, come out from the application file. May read the application filed by the
Application was under order on Rule 10, right?
Yes.
Filed by the
respondents 8 to 13. They simply say
8 to 30.
we are necessary party, we have to come on record without even disclosing your lordship how they are related to the plaintiffs and others.
Sorry, madam.
In such an event, say the respondent number 9 to 13 have remained unrepresented here. So why don't you ensure the service of notice upon the learned counsel who appeared for them in the trial court? Because they have come, they have got impleaded at their instance. So since you challenged the said very order of impleading them.
What happened was, it is the 8th respondent who filed the application. Your lordship.
Where is that application?
Lordship gets it at page 32. Your lordship. They have sworn affidavit on behalf of others stating that they are necessary parties. Page 32, annexed D. Madam.
No, it is not respondent number 8 who has filed application. It is including applicants themselves have filed. It is the applicants themselves have filed the application.
Affidavit, your lordship. He has sworn to the affidavit on behalf of others also. Next page, your lordship gets it at page 34.
With counsel affidavit sworn by not any original defendant.
Yes, sir.
It is one among the applicant. One among the applicant. That's what I have been telling. So since the application is filed by not any of the existing defendants, then
no.
not even by plaintiff, it was by stranger to the suit.
Yes, sir.
Those strangers are required to be heard because they, by filing the application, they were indicted.
Yes, sir.
For some reason, even though the notice has been served upon them, they have not appeared here. So before taking any decision whether they are required to be continued as defendants or they are required to be dropped out, the natural justice warrants that they must be heard. Option is 2. 1, appointing an amicus curiae, in which an event, like in the previous exercise, you have to furnish every detail. Probably you yourself may not have those details because they are the impleading applicants. In the previous case, they were not impleading applicants. As such, I appointed an amicus curiae. In this case, I am not going to appoint because even to assist amicus curiae by furnishing the papers, you yourself will not be in possession of any of those papers based upon which they intend to implead themselves. As such, the right point would be, even though the service against them has been held as sufficient, but still,
I will make efforts.
Yes, survey copy to the learned counsel in the trial court. Then we will proceed.
Respondent number 8, who are others are brothers.
But they may be brothers, but
I understand them.
legally they are different persons. 45 ವರ್ಷ ಇದೇ ಪಾಠ ಮಾಡಿದ್ದೀರಿ ನೀವು ಮತ್ತೆ ನಿಮ್ ಜೂನಿಯರ್ ನಿಮಗೆ ಹೇಳೋದು ನೀವೇನೋ ಹೇಳೋದು ಏನ್ರಿ ಅದು ವಕೀಲ್ರೆ
I will try to take I will try to serve
ಅಷ್ಟೇ ಮುಗಿದೋಗ್ತದೆ ಕತೆ.
Have it on
Yes, learned counsel for the petitioner.
16th or 17th.
Who is appearing for respondent number 8? You said say you are appearing to video conference.
Yes, my lord. Appear for the.
You have any instruction to appear for the remaining respondents 9 to 13?
No, on record, counsel.
Can you take instruction and file wakalat for 9 to 13 also? Because it appears that all of you are sailing in the same boat.
My lord, on record, counsel is a personal inconvenience, my lord. Kindly have it on. Any date will be given, my lord.
is physically present, learned counsel for respondent number, learned junior counsel for respondent number 8 is appearing. Junior counsel, but learned counsel for respondent number 8 is appearing through video conference. After hearing the submission of learned counsel for the petitioner and perusing the petition, it appears that the impugned order is an order passed on the impleading application filed under Order 1 Rule 10 CPC by the applicants therein who filed the applicants therein who were not the original defendants. The plaintiff, the said application since has neither filed by the plaintiff or nor by then existing defendants. Those applicants may have to be, may require to be, may have to be heard before proceeding in this petition. Though the notice has been served upon respondent number 9 to 13, but they have remained unrepresented. As such, the court asked the learned counsel for respondent number 8 whether he would get instruction from respondent number 9 to 13 and appear for them by filing wakalat. Since present respondent number 8 is also one of the applicant, right? Since said respondent number 8 is also one among the applicants who got impleted themselves. They said learned counsel prays for a week's accommodation. In the meantime, learned counsel for the petitioner is also requested to take out a notice by hand upon the learned counsel for the unrepresented respondent number 10, 11, 12, and 13, wherein who were the applicants in the trial court in order in IA number. In the IA and order filed under Order 1 Rule 10 CPC. So that if they said the learned counsel could be able to get an instruction and make arrangement for the representation of the unrepresented respondents, through a counsel. The same can be done. This is the matter in the week after next. R9 to 13.
Seal number 25, Sri Bhaskar Babu HJ for the petitioner. Rosai Mutt is served.
None appear in this matter, either physically or through video conference. This matter is not proceeded to.
26.
Okay, for the
Sri SM Babu for the petitioner, V. Srinivas for 1 to 4.
I represent respondents, my lord. May I request for a copy of the petition to my friend, which will be furnishing. May I request for a week's accommodation.
counsel from both sides present. At the request of the learned counsel for respondent number 1 to 4, learned counsel for the petitioner has furnished.
I'll furnish them.
A set of copy of the memorandum of petition as requested by learned counsel for the respondent. A week's accommodation is granted.
Some date, my lord. Some date.
1 week means it will come exactly in 1 week in my court.
I'm not in session from Friday to next Saturday.
Week after next day. You can comfortably go and come. Week after next month.
Seal number 27, Sri Siddhalappa PM for the petitioner, Sri Suman Prakash for R3 and 4, and M.B. Chandrachud for R1.
Yes.
Bit of the petitioner's fee, my lord.
Why you wanted to drag on the matter for such a long time?
The miscellaneous appeal, please, my lord.
All say commencing from the original suit up to miscellaneous appeal.
What has happened before the miscellaneous appeal is that the records was misplaced. Miscellaneous proceedings was filed in the year 2009 and it was
Records are misplaced where?
before the senior division. There is an observation also, please, my lord. Misplaced, and after publishing all the documents by the respective councils.
No, forget about the first appellate court in the miscellaneous. Say the original order is that say the suit was dismissed for default. That is it. You have to convince that reason, not the misplacing of the record. This itself shows the conduct of the plaintiff. ಅವ್ರು ಮಾಡೋ ತಪ್ಪುಗಳೆಲ್ಲ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನೋ ಒಂದಾದ್ರೆ ಅದೇ ದೊಡ್ಡ ತಪ್ಪು. If that were to be the attitude, where is the ground for you? ಯಾವುದೇ ವಕೀಲರು ಇದ್ದವ್ರು ತಮ್ಮ ತಪ್ಪಲ್ಲ ತಾವೇ ಕರೆಕ್ಟ್ ಉಳಿದಿದ್ದೆಲ್ಲ ಉಳಿದವ್ರದ್ದು ಅಂತ ಯಾರು ಬೆರಳು ತೋರಿಸ್ತಾ ಬರ್ತಾರೆ ಅಂತದ್ರಲ್ಲಿ ಕೋರ್ಟ್ ಬಹಳ ಜಾಗರೂಕವಾಗುತ್ತೆ.
Being a senior citizen, his age around as on the date of filing the suit, he was aged around 75 to nearly 80 years. Please, my lord.
No, you could have produced a medical certificate.
And on the date of when the order of dismissal was dismissed, please, my lord, he was suffering from loose motion and some giddiness. A medical certificate ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ that was the ground.
ರೀ ನಿಮಗೆ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಏನ್ ಅನಾನುಕೂಲತೆ ಇತ್ತು? ಅದಕ್ಕೆ ಮುಂಚೆನೂ ನಿಮ್ಗೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. The trial court has observed that sufficient time has already been granted. ಪದೇ ಪದೇ ಟೈಮ್ ಕೊಟ್ಟು ಸಾಕಾಗಿದೆ. ಎಷ್ಟು ವರ್ಷ 22 years as on date. ನೀವು ಯಾರಿಗ್ರಿ?
ನಾನು ಡಿಪೆಂಡೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ಬೋದು ಅವರಿಗೆ?
ಅಷ್ಟು ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಯು ನಾಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಟೇಕ್ ದ ಪ್ಲೇಂಟ್ ಅನೆಕ್ಸರ್ ಎ ಪೇಜ್ 60. ತಂದೆ ಮಗಳ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ತಾರೆ, ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್. ತಂದೆ ಮಗಳ ಮೇಲೆ ಹಾಕೋದು ಸೂಟ್
ಹಾಕಬಾರ್ದು ಅಂತಿದೆಯೇ? ಮತ್ತೆ
ಪ್ರಾಪರ್ಟಿ ಗಿವನ್ ಟು ದಿ ವೈಫ್ ಅಂಡರ್ ದಿ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಂಟೆನೆನ್ಸ್, ಅದು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸೂಟ್ ಹಾಕ್ತಾರೆ ಅಮ್ಮ ತೀರ್ಕೊಂಡ್ಮೇಲೆ.
ಅಲ್ಲ ಈಗ ನಾವು ಮೆರಿಟ್ ಮೇಲೆ ಇಲ್ವೇ?
ಅಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಗಿವನ್ ಟು ದಿ ಫಸ್ಟ್ ವೈಫ್.
ಈಗ ಸೂಟ್ ಪ್ಲೀಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಬರಲ್ಲ ಇಲ್ಲಿ.
ಈಗ
ವೆದರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಾಸ್ ರೈಟ್ ಇನ್ ಡಿಸ್ಮಿಸಿಂಗ್ ದಿ ಸೂಟ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್.
ನನ್ನ ಪ್ರಕಾರ ಸರಿ ಇದೆ ಅಂತ ಐ ಕ್ಯಾನ್ ಸೇ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಆಮೇಲೆ ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ವೈಫ್ ಮಾತ್ರ ರಿಟ್ ಹಾಕ್ತಾರೆ, ಮಿಕ್ಕವ್ರು ಯಾರು ಹಾಕಲ್ಲ. ರಿಟ್ ಹಾಕಬೇಕಾದ್ರೆ ಮಿಸ್ಲೇನಿಯಸ್ ಅಷ್ಟೇ. ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ ಬೇಕು.
ಆ ಪಾಟಿ ಮಲತಾಯಿಗೂ ಮಗಳಿಗೂ ಇರೋದು ವೈಷಮ್ಯ ಇರ್ಬೋದು, ಇರ್ಲಿ ಬಿಡಿ. ಈಗ ಮಲ್ತಾಯಿ ಆಯಸ್ಸು ಅದೇ ಇದ್ರಲ್ಲಿಯೇ. ಕೆಲವರಿಗೆ ಮೈ ಮೇಲೆ ಗುಳ್ಳೆನೋ ತುರ್ಕೇನೋ ಕಜ್ಜಿನೋ ಇದ್ರೆ ಕರ್ಕೊಳ್ತಾ ಇರೋದೇ ನೆಮ್ಮದಿ. ಅದಿಲ್ಲ ಅಂದ್ರೆ ಏನೋ ಕಳ್ಕೊಂಡಂಗ ಆಗುತ್ತೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡ್ತಾರೆ, ಯಾರಿಗೂ ನೆಮ್ಮದಿ ಇಲ್ಲ ಅಷ್ಟೇ. ದಿಸ್ ಇಸ್ ಹೌ ಇಟ್ ಸ್ಟಾರ್ಟ್ಸ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು. My friend took time to consult the client to withdraw the petition. This is how
ಏನ್ರಿ ಈಗ ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಒಪ್ಪಿದ್ರೇನ್ರಿ?
Court was of the opinion that you go and file a separate suit. And this court was formed the opinion. This being a declaration suit without permission of my counterpart and my client, I cannot give consent. ಹಾಗಾಗಿ I sought time. ಒಂದು ಜನರೇಷನ್ ಹೋಯ್ತು. That was the main reason for at that date.
ಅದ್ರಲ್ಲಿ ಯಾವ್ದು ವಿಶೇಷ ಇಲ್ಲ ಅಲ್ವೇ? ಭಾರತೀಯ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ವಂಶವಹಿಯಾಗಿ ಪ್ರಕರಣಗಳು ದಾವೆಗಳು ಮುಂದುವರಿಯೋದು.
ಇದು ತಂದೆ ಮಗಳ ಮೇಲೆ ದಾವೆ ಅಷ್ಟೇ, ನಾನು ಬೇರೆ ಇನ್ನೇನು ಹೇಳಲ್ಲ. ಐ ಲೀವ್ ಟು ದಿ ಕೋರ್ಟ್. ತಂದೆ ಮಗಳ ಮೇಲೆ ದಾವೆ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಕಾಮೆಂಟ್ ಎನಿಥಿಂಗ್ ಮೋರ್ ದನ್
that.
Permitted to go to the
Yes. The husband of the present petitioner had instituted a suit against the present respondent number 1, arraigning her as defendant number 1 in the trial court in OS number 20/2001 for relief of declaration and perpetual injunction. The defendant appeared through her counsel and was contesting the matter. When the matter was at the stage of plaintiff's evidence, since the plaintiff therein remained absent even after granting him the sufficient opportunities, the trial court, by its order dated 2/12/2004, dismissed the suit for default. Seeking recalling the said order, the plaintiff filed a miscellaneous petition under Order 9, Rule 9 of CPC, which also came to be rejected by the order dated 11/6/2009. Challenging the said order, the legal representatives of the original plaintiff prefer miscellaneous appeal number 5/2009 under Order 9, Rule 9 CPC, under Order 43, Rule 1 CPC in the First Appellate Court, which also, after hearing both sides, dismissed the appeal. Agreed by the same, the first legal representative of the deceased original plaintiff is before this court as a petitioner in this petition. The learned counsel for the petitioner submits that since the suit was the one for declaration and injunction, the trial court ought not to have dismissed the suit, that too without giving reasonable opportunities for the plaintiff to appear and to lead his evidence. He further submitted that the statement made, you have filed adjournment application, right? Have you produced the copy of the same? No. Whether that application was accompanied with affidavit?
Complete with the memorandum of fact.
The statement made in the memorandum of facts to the effect that the plaintiff was suffering, the plaintiff who was aged person was suffering with ಏನೇನೆಲ್ಲ ಕಾಯಿಲೆಗಳು, ಕರೋನಾ ಅಲ್ಲ, ಕೋವಿಡ್ ಅಲ್ಲ, ಅವಾಗಿರ್ಲಿಲ್ಲ. ಲೂಸ್ ಮೋಷನ್, ವಾಂತಿ, ಬೇದಿ, ಜ್ವರ, ತಲೆ ಸುತ್ತುವಿಕೆ, ಹೈ ಬಿಪಿ, ಡಯಾಬಿಟಿಸ್, ಅದು ಎಲ್ಲದು ಇತ್ತು. ವಾಕಿಂಗ್ ಸ್ಟಿಕ್ ಒಂದು ಬಿಟ್ಟು ಉಳಿದಿದೆಯಲ್ಲ. ಏನ್ ತಗೊಂಡ್ರಿ? Was suffering with the age related ailments, and incidentally on the said day he was suffering with heavy loose motion and vomiting. Still, the court, only on the ground that no medical certificate was rejected, proceeded to dismiss the suit for default, which was further confirmed by the subsequent orders, including in MA 5/2009 for the same reason. As such, those orders deserve to be set aside. Per contra, learned counsel for Which respondent?
Respondent number 1, Your Lordship.
Respondent number 1, in his argument, submitted that the suit is between father and daughter, and that for no valid reasons, the plaintiff had remained absent on the date when the suit came to be dismissed for default. Next one. A perusal of the certified copy of the pleading, certified copy of the plaint and the impugned orders filed by the petitioner, along with the memorandum of petition, go to show that after the matter for the first time listed for the plaintiff evidence, 4 adjournments were granted. 5 adjournments were granted to the plaintiff to lead his evidence. However, the plaintiff did not lead his evidence as such. On the 6th such adjournments, the trial court proceeded to dismiss the suit for default. No doubt, on 2/12/2004, when the impugned order of dismissal was passed, the plaintiff had filed an adjournment application. However, the trial court, noticing that no medical certificate was produced along with the adjournment application, has proceeded to dismiss the suit for default. In this impugned order, the trial court has not considered as to what reason the plaintiff has shown for his absence on the said day, whether the medical ailments mentioned by him really was warranting a production of a medical certificate, or whether the court could have been satisfied by the statement made in the adjournment application has not been considered by the trial court. In its cryptic order of a single sentence, which resulted in in its cryptic order of 3 sentences, which has resulted in the dismissal of the suit. Incidentally, while disposing the recalling application filed under Order 9, Rule 9, CPC, also the trial court has highlighted only the fact of non-production of the medical certificate, but has not considered the alleged fact that if the plaintiff was suffering with loose motion and vomiting on the very same day, was it reasonable to expect production of the medical certificate immediately for its production in the trial? Thus, the circumstance of the case appears to have not been properly appreciated by the trial court. The same error was continued with the First Appellate Court in MA 5/2009 also, which, without attributing any reasons, has repeated the reasoning shown by the trial court and confirmed and dismissed the appeal before it. As such, I am of the view that as an ultimate opportunity, one more opportunity be given to the plaintiff to proceed with this suit, making it clear that they shall not seek for any adjournment in the trial. At the same time, considering the age of the original suit, which is of the year 2000 and thus 22 years old suit, and also the enormous and precious time of both the trial court as well as the First Appellate Court has been eaten away in the said process, imposing a cost is also found to be reasonable. Since the respondent number 1 submits that he is not concerned for the cost going to be ordered now would be payable to the legal services authority of the court where the original suit is pending. Accordingly, the writ petition stands allowed, however, on a cost of rupees 10,000 payable by the petitioner hearing to the legal services authority in the trial court where the original suit is pending. ಅಲ್ಲಿ ಇರ್ತದೆಯಾ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಕಮಿಟಿನ ಅಥಾರಿಟಿನ ಏನದು ಅಸರ್ಟೈನ್ ದಟ್ ಅದನ್ನ ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೊಂಡು ಹಾಕಿ ತಾಲೂಕಾ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಯಾವ್ದಿರುತ್ತೆ within 7 days from today and filing a complaints memo along with a certified copy of this order in the trial court. A complaints memo, a receipt for having paid the cost along with a certified copy of today's order in the trial court within the set period of 7 days. With such an event, the trial court shall take up the matter for its further proceedings from the stage where it was as on the date of dismissal of the original suit. In order to avoid any further delay, both side parties who are appearing in this writ petition are directed to in order to avoid any further delay, the respondent number 1, 3, and 4 who are respondent number 1, 3, and 4 hearing are directed to appear in the trial court on 28 ಇವತ್ತೆಷ್ಟು ತಾರೀಕು 9 ಒಂದು ವಾರದೊಳಗೆ 21 ಮಾಡಿ 21 23 ಮಾಡಿ 23/3/2022 at 11 a.m. without anticipating any fresh summons or notice from the trial court. The said trial court, it is appreciated that if the said trial, it is appreciated the trial court disposing of the said original suit in accordance with law at the earliest but not later than 4 months from the said date. Both side parties to cooperate with the trial court in the early disposal of the suit. ಇಪ್ಪತ್ತೆರಡು ವರ್ಷ ಆಗಿದೆ, ಈಗಲೇ ಹೋಗಿ ಬೇರೆ ಮ್ಯಾಟರ್ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ, ಈಗಲೇ ಪಾರ್ಟಿಗೆ ಹೋಗಿ ಪಾರ್ಟಿ ಫೋನಲ್ಲಿ ಸಿಕ್ಕದೆ ಹೋದ್ರೆ ಹತ್ರ ಇದೆ, ಒಂದು ಕಾಲು ಗಂಟೆ ಜರ್ನಿ. ನೀವು ನಿಮ್ಮ ಮೋಟರ್ ಸೈಕಲ್ ಹೋದ್ರೆ ನಿಮ್ಮ ಸ್ಪೀಡ್ ನಲ್ಲಿ 40 ನಿಮಿಷದ ಪ್ರಯಾಣ, ಹೋಗಿ ಪಾರ್ಟಿಗೆ ಹೇಳಿ ಹೀಗಾಗಿದೆ.
Cell number 28, Sri Siddharth Suman for the petitioner. Sri V. Manjunath for the respondent.
On the last occasion, it was said the adjourned due to the absence of the learned counsel for the respondent. You are ready. The same is situation today. How to proceed? Hearing would be of the very important and necessary in this matter.
I quite see.
So you are the tenant.
But it's not anymore. No. That is my contention.
So no proposed owner. Yes. So the alleged vendor, ex-landlord, is a must. Learned counsel for the petitioner alone is physically present in the court. None appear for the respondent, either physically or through video conference. No reasons are forthcoming for non-appearance of learned counsel for the respondent in this matter. On the previous date of hearing, which was on 4/3/2022 also, it was the learned counsel for the petitioner who alone was present in the court. The matter was passed over only to enable the learned counsel for the respondent to appear and participate in the proceeding. As such, the matter was called in the afternoon session. Then also the learned counsel for the respondent had remained absent, though the learned counsel for the petitioner was again physically present. However, considering the nature of the impugned order challenged in the writ petition, the court thought that before proceeding further, it is better to give a final opportunity for the respondent to appear and proceed further in the matter. As such, the matter stood adjourned to today. Even today also the respondent, even today also the learned counsel for the respondent is neither present nor has shown any reason for his non-appearance. As such, though the matter could have been proceeded in the absence of the learned counsel for the respondent, however, as aforesaid, considering the nature of the impugned order, I am of the view that an amicus curiae be appointed for the respondent. Accordingly, learned counsel Srimati K.M. Archana, who is present in the court, is appointed as an amicus curiae for the respondent in this matter. Learned counsel for the petitioner, adenéniದೆ ನಿಮ್ಮ ಹತ್ರ entire set in bundle. ಒಂದು ಸೆಟ್ ಕೊಡಿ, ಜೆರಾಕ್ಸ್ ಕಾಪಿ, ಒರಿಜಿನಲ್ ಕೊಟ್ರೆ ಆಮೇಲೆ ನಿಮ್ಮ ಹತ್ರ ಇರಲ್ಲ. ಅವರಿಗೆ ಪ್ಲೀಡಿಂಗ್ ಕಾಪಿಯೂ ಇರಲ್ಲ, ಪ್ರೀವಿಯಸ್ ನಲ್ಲಿ ಏನು ಹಾಕಿದ್ದೇನೆ ಅದಷ್ಟನ್ನು ಹಾಕಿದ್ರೆ ಪ್ಲೀಡಿಂಗ್ ಕಾಪೀಸು ಇರಲ್ಲ. ಹಾಗೆ ಪ್ಲೀಡಿಂಗ್ ಕಾಪೀಸ್ಗಳು ಕೇಳಿದ್ರೆ ಅದ್ರದ್ದು ಎಲ್ಲ ಫೋಟೋ ಕಾಪಿ ಒಂದೊಂದು ಕೊಡಿ, so that she can proceed in the matter. But the point is that when there is a contention of the pendency of this suit for specific performance, can an alleged previous tenant who claims himself to be the subsequent owner of the property under the alleged agreement of sale be evicted by continuation of the eviction suit? That means whether the eviction suit deserves to be stayed under section 10 of CPC. Ashte, section 10 CPC. ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. ಆನರಬಲ್ ಲಾರ್ಡ್ಶಿಪ್ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಸಾಹೇಬ್ರದ್ದು ಜಜ್ಮೆಂಟ್ ಅವ್ರು ರಿಲೇ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಮುಂಚೆ 2007 ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, 2017 ಇನ್ನೊಂದಿದೆ, ಪ್ರಾಬಬ್ಲಿ ವಿಚ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ನೋಟಿಸ್. ಅದನ್ನ ನೋಡಿ ಅಂಡರ್ ವಾಟ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಪ್ರೊಸೀಡಿಂಗ್ ಕ್ಯಾನ್ ಬಿ ಸ್ಟೇಟ್ ಅಂಡ್ ವಾಟ್ ನಾಟ್ ಅನ್ನೋದನ್ನ ಇಬ್ರು ಸೇರಿ ಎನ್ಲೈಟನ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು, ಪೂರ್ತಿ ಏನ್ ಬುದ್ಧಿ ಕೊಡುತ್ತೆ ಆರ್ಡರ್ ಮಾಡು. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. ನಿಮಗೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರದೇ ಇಲ್ರಿ, ನಿಮ್ಗೆ ಯಾಕೆ ದುಃಖ ಅಲ್ವಾ? ನೋಡಿ ಎಷ್ಟು ಖುಷಿಯಿಂದ ಈಗ ಹೂ ಅಂತಾರೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರ ಅಂದ ಕೂಡಲೇ.
2002
ಹೌದು ಆಗ್ತಿದೆ ಅವ್ರಿಗೆ. ನೀವು ಎಷ್ಟು ಬೇಗ ಪೇಪರ್ ಕೊಡ್ತೀರಿ ಅಷ್ಟು ಬೇಗ ಅವ್ರು ಓದ್ತಾರೆ. ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್. Interim order granted earlier is extended by 2 weeks from today.
29, say
28.
List the matter on 28/3. 28/3, the interim order granted earlier is extended till then.
Number 29, Sri Ramchandra for the petitioner, Sri Prakash for Cabinet number respondent number 1.
I represent
for auto.
And for Ramchandra Milord that I appear.
Setback parliamentary.
ಈಸ್ಟ್ ಒಂದು ಸೈಡ್ ಸೆಟ್ ಬ್ಯಾಕ್
ಅವಾಯ್ಡ್ ಮಾಡಿ ಸ್ಟೇರ್ ಕೇಸ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಹೌದು,
ಕಾರ್ಪೊರೇಷನ್ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಕಾರ್ಪೊರೇಷನ್ ಅವರು ಏನ್ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ನಾವು
ಯಾರ ಮೇಲೆ ತಗೊಳ್ತಾರೆ ಅವರು? Who have filed? Why two IAS under Order 39 Rule 1 and 2?
Only one the IA is for to restrain the first defendant for further construction in the plain schedule property. Subsequently, the plaintiff filed an application IA3 under Order 39 Rule 1, praying for an order of status quo ante, directing the defendant to dismantle, demolish, and remove the illegal construction undertaken by the
Both IAS were under Order 39 Rule 1 and 2.
It is 40.
The petitioner is ready.
Yes, my lord.
We'll continue in the afternoon then.
Please.
Your lordship permission. Next matter. Seal number 13.
After this matter.
No.
After this ongoing matter.
Next matter, 38, 30. No, I request some 10 days adjournment. Was the person who is not the senior advocate is from Delhi. Today is not very well, so that instruction I've taken. So 10 days. Because one more matter which is
whom you appear for?
Not petitioner. I already. Other side advocate also.
At the request of the learned counsel for the petitioner, 10 days time as spread is granted. Yes.
Your lordship, kindly, my lord.
ಈಗ ಮೆಮೊ ಹಾಕಿದ್ದೀರಿ ನೀವು ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಏನು
ಡಿಸ್ಪೋಸಲ್ಗೆ ಹಾಕಿದ್ದೆ ಹಿಂಗೆ ಈಗ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಪಿಟಿಷನರ್ ನಂಬರ್ 2 ಅದು ಇವತ್ತು ಹೇಳಿದ್ರು ಅದರ ಸೈಡ್ ನನಗೆ ರೆಕಾರ್ಡ್ ಬೇಕು ನಾನು ಅಡ್ವೊಕೇಟ್ಗೆ ಟ್ರಯಲ್ ಅಡ್ವೊಕೇಟ್
ಅಲ್ಲ ಮುಂಚೆ ಹಾಕಿದ್ ಮೆಮೊ ಯಾವ್ದಕ್ಕೆ ಹಾಕಿದ್ ನೀವು
ಅದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿದ್ದಾರೆ ಆಮೇಲೆ ಎಲ್ಲ ಅಪಿಯರ್ ಆದ್ರು ಅದು ಇಯರಿಂಗ್ ಇಯರ್ ಆಯ್ತು ಅಡ್ಮಿಟ್ ಆಯ್ತು ಇವಾಗ ಅದನ್ನ ಹಂಗೆ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅದಕ್ಕೆ ನಾನು ಅದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ ಅಂತ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದೆ.
The request of the learned counsel for the petitioner, 10 days time as spread is granted.
Lordship, kindly, my lord.
Lordship. 39. That's a route motor vehicle route matter.
ಬೆಳಗ್ಗೆ ಯಾರೋ ನಿಮ್ಮನ್ನು ಹುಡುಕ್ತಾ ಇದ್ರು
ಬೆಳಿಗ್ಗೆ
ಯಾವ್ದೋ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತ
ನನಗ ಕೆಲವೊಂದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬೇಕು ನಾನು
ಇದರಲ್ಲಿ
ಅದರಲ್ಲಿ ಮ್ಯಾಡಮಸ್ ಕೇಳಿದ್ದಾರೆ ಇಲ್ಲಿಗಲ್ ಆಪರೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಆಫ್ಟರ್ ಕಮಿಂಗ್ ಇನ್ ಟು ದಿ ಕೋರ್ಟ್ ಆಫ್ ದಿ
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತವ್ರಿ ಬಿಡಲ್ಲ ಪರಸರ ಕುಮಾರ್ ಅವರು ಅವ್ರು ಪರ್ಮಿಟ್ ಇಲ್ಲದೆ ಬಸ್ ಓಡಿಸಿ ನಿಮ್ಮನ್ನ ಚೇಸ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತಾರ
ಫಾರ್ಮಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ನಾನು
ಇಟ್ಸ್ ಅ ಮೂಡ್ ಮ್ಯಾಟರ್
ಅವ್ರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ
ಅವ್ರು ಮೂವ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಅವ್ರು ಒಂದು ಮಾತು ಕೇಳ್ಬೇಕಲ್ರಿ
ಹೇಳಿದ್ದೀನಿ ಅವನಿಗೆ ಹೇಳಿದ್ದೀನಿ ಆಕ್ಚುಲಿ ವಾಟ್ ಹ್ಯಾಪನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ನಾನು ಇವತ್ತು ಇರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೆ ನಾನು ಅವರಿಗೆ ಇವತ್ತು ಇರೋದಿಲ್ಲ ನಾನು ಸ್ಟೇಷನ್ ಇರೋದಿಲ್ಲ ಅಂತ ಎಕ್ಸ್ಟ್ರಾ ಐ ವೆಂಟ್ ಟು ಚೆನ್ನೈ ಟು ಅಟೆಂಡ್ ಎ ಮ್ಯಾಟರ್ ಟ್ರಿಬ್ಯುನಲ್ ಗ್ರೀನ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಆನ್ ದ ವೇ ಹೋಗುವಾಗ ಫೋನ್ ಬಂತು ಅದು ಎಜರ್ನ್ ಆಗಿದೆ ಮ್ಯಾಟರ್ ಅಂತ ಇವತ್ತಿಂದ ವಾಪಸ್ ಐ ಕೇಮ್ ಬ್ಯಾಕ್ ದಟ್ಸ್ ವೈ ಈಸ್ ನಾಟ್ ಕಮ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಈಗ ಅವ್ರಿಗೆ ನೀವು ಹೇಳಿದ್ದೀರಾ
ಹೇಳಿದ್ದೀನಿ ಈ ನೋಸ್.
At the request of the learned counsel for respondent number 4, the matter stands adjourned by a week. Yes.
Next week,
Whom you appear for?
petitioner.
At the request of the Learned Counsel for the petitioner, as finally 1 week time as paid is granted.
Serial number 31, my lord.
ನಿಮ್ದು ಆಗಿದೆ ಒಂದು ಚಾನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ 42. ಎಂಟ್ರಿ ಮಾಡೋದ್ರೆ ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ಹೇಳ್ಬೇಕು. ಮಧ್ಯ ಮೂವ್ ಮಾಡಿದಾಗ ಎಂಟ್ರಿ ಮಾಡೋರ್ಗಳು ಎಂಟರ್ಟೈನ್ ಮಾಡೋಲ್ಲ.
Your lordship, kind leave, my lord.
Whom you appear for?
He filed wakalat, my lord, Anand, for a week's time.
No. Have you filed wakalat?
We filed wakalat.
When did you file?
We filed it in the morning, my lord. So a week's time will be given, my lord. My colleague just gave me a call and said, file a counter a week's time to appear before the court and appeal the court.
No. By filing a wakalat, you get any cause of action to seek adjournment?
Copy of the.
No, you are making submission in such a manner that today I have filed wakalat. My colleague has filed it. Give me a week's time.
Sorry, my lord.
Sir, ನೀವು wakalat file ಮಾಡ್ಲಿಕ್ಕೆ adjournment ಮಾಡ್ತಾ ಇದ್ದೇವೆ ನಾವು.
Sorry, my lord. We received the copy 3 days back, my lord. On the.
First, let me confirm that you have filed wakalat. Ascertain from the registry whether the wakalat has been filed. Ilda hodre say I will appoint an amicus curiae in that matter. If wakalat is not coming before me by 2:30. Yes.
Your lordship, kindly, my lords.
Serial number 31. For the petitioner.
Yes. Yes.
Next week.
Yakri.
41 ಇದೆ ಅದ್ರಲ್ಲಿ ready
At the request of the ದಿವಸ ಜಾಸ್ತಿ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಎಲ್ಲದರಲ್ಲೂ ರೆಡಿ ಆಗ್ಬೇಕಲ್ವೇ? ಮನೇಲಿ ನೆಂಟರು ಜಾಸ್ತಿ ಬರ್ತಾರೆ ಅಂದ್ರೆ ದೊಡ್ಡ ಸೈಜ್ ಕುಕ್ಕರ್ ಇಟ್ಕೊಳ್ಬೇಕು. 5 ಲೀಟರ್ ಕುಕ್ಕರ್ ಆಗಲ್ಲ ಅವಾಗ. At the request of the Learned Counsel for the petitioner, a week's time as paid is granted. Yes.
Serial number
mention ಏನಿದ್ರು ಕೂಡ ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ, not before that.
Serial number 39.
Yes.
ಭಂಡಾರಿ ಏನು ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋತೀನಿ ಅಂದ್ರು ಸರ್.
ತಗೊಂಡ್ರು ನಿಮಗೆ ಹೇಳಿದಾರಂತೆ ಮಧ್ಯಾಹ್ನ
ಅವರು ಚೆನ್ನೈಗೆ ಹೋಗ್ತೀನಿ ಅಂದ್ರು ನಾನು ಅಡ್ಜರ್ಮೆಂಟ್
ವಾಪಸ್ ಕರ್ಸಿದ್ರಂತೆ. ಚೆನ್ನೈಗೆ ಹೋಗೋರ್ನ ಇನ್ನೊಮ್ಮೆ ಹಾಗೆ ಮಾಡಬೇಡಿ.
ಅಲ್ಲ
ಬಸ್ ಬಿಡ್ತೀರಿ ಅವ್ರಿಗೆ ಹಂಗ ಆಗಲ್ವೇ?
ಅವರ
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವರು.
Serial number 31, my lord.
31 ಏನ್ರಿ?
I appear for respondent, my lords, in this matter.
ಆಯ್ತು, ಅದು 1 week adjournment ಆಗಿದೆ ನೋಡಿ.
Oblige, madam.
Next week. ತಮ್ಮದು serial number 45. ಅದನ್ನ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು. ನಿಮ್ ಕೈಗೆ ಆಗಲ್ಲ ಅಂದ್ರಲ್ಲ, ULC ಮ್ಯಾಟ್ರು. Your colleague said on the previous occasion that you are addressing argument because it is a ULC matter. You have made your colleague to study. Move and read. No, I will direct you to address argument. The request of the learned AG, a week's time as spread is granted. Other side, Haley, Venugopal avರಿಗೆ 1 week. ಬರ್ತದೆ, ಒಂದು ವಾರಕ್ಕೆ ಬರ್ತದೆ.
I want to make one submission. Yesterday, one matter was there, serial number 44. I held up in a trial court because I waited 3 o'clock in the court, Lordship. Then some urgent witness was there, government witness. I went there by the time matter was called. Lordship, please to adjourn the matter for 8 weeks. Some urgency was there, Lordship. I will move. I'll file application to set aside the order, yesterday's order, Lordship. Kindly explain, Lordship.
No, some submissions the court would hear, some submissions the court cannot hear. So I haven't heard that submission.